That's now live.
Thank you. Well, good morning and welcome to day 3 of the proposed Fetteresso wind farm inquiry. Today we'll conclude the inquiry session with evidence presented by Mr. Clapham on behalf of the Fetteresso Community Council, and we'll hear from local residents too. We'll also hold the second hearing session on draft conditions that may be attached to a Section 36 consent and deemed planning permission should the Scottish Ministers resolve to grant consent to the application. Now, before we proceed, I'd like to take a note just to confirm who will be taking part in this inquiry session this morning. And I'll start with the applicant, Mr. Innes.
Yes, good morning, sir. My name is Colin Innes. I'm a partner in the law firm of Shepherd Wedderburn and appear on behalf of the applicants at this continued inquiry session. I'm also accompanied this morning by Mr. Brian Denny, landscape architect, who has already given evidence of Pegasus Planning Group. And those are the 2 representatives of the applicant who will be participating in this session today.
Thank you very much. Mr. Finlay, do you tend to simply observe the proceedings this morning, or do you wish to take part?
I wish simply at the moment to observe, but reserve the right to take part if needs be. Perhaps confusingly, we have Mr. Hewitt's name on our form, but that's for the next session primarily, so we don't have to change that when we go through. But it will just be me for this session, and I hope I don't have to say anything. But okay. I'm observing primarily.
Okay, well, thank you very much for that. I can see Mr. Clapham there, so I have you.
Yes, good morning.
Yes, Mr. Burgoyne, I've heard from you. Mr. Cole is unavailable. Mr. Kilford has already given prior notice that he was unable to attend. I can see Mr. Strawn there. Yes, I'll be hearing from you later. And then Mr. Walker. Okay. My intention would be to hear from Mr. Clapham first, then I'll hear from Mr. Burgoyne, and then Mr. Strawn, I'll hear from you last, if that's okay. Before we proceed, I wonder if there's any matters that people wish to raise, any questions they wish to ask. Okay, on that basis, then we'll proceed.
About the process, or to
about the process? It's
yeah,
about the
okay.
process.
No, that's fine. That's fine.
Okay. Mr. Clapham, I see that yesterday you asked where you could view a recording of yesterday's proceedings. I hope you were able to access that recording to assist you in preparing for today.
Yes, indeed. I hope you can hear me. Yes, indeed, I did manage to access the recording. So thank you to your team for arranging that. And indeed, I went over. There was just that specific area that I wanted to go over of Mr. Denny's evidence. But thank you for doing that. Yes.
Okay. Well, if you'd like to present your evidence, the floor is yours. Thank you.
Okay. Thank you very much indeed. And thank you to Mr. Sykes specifically. I'm new to this process, so I'd like to thank everybody who's been involved with this. It's been very clear, and I've been impressed by the way the whole thing's been conducted. I'll introduce myself again, just to make sure everybody knows who I am. My name is Ross Cleffin. I'm here representing Hewside Community Council. So we represent the communities to the north of the proposed wind farm. That's in those in Strawn, Orcatty, Blackhall, Bridgefew, Glendy and Tilquilly. So a number of small villages around there to the north. I would like to say it's disappointing there's been no specific representation at the inquiry from the community councils of Auchenblay and Glenbervie. But I do know that several statements from local residents in those areas have been submitted, and I think there, in some respects, those local residents, of course, are much more affected by the proposed development than we are to the north of the proposed development. Our written inquiry statement is broadly aligned with the statement of agreed matters which we've made with the applicant. And in order to gain agreement from the other council members, there are 10 of us. We did go through 8 iterations of the statement of agreed matters. And it was easier from our point of view to keep all our comments together in one document, but I will try to minimize any repetition here. Recognising the climate change imperative, of course, and what's going on in Glasgow right now, we do wish to give broad support for the proposed development, but with a couple of reservations. And I would like to say that we do not intend to support further future increases in wind farm capacity in this area, and we particularly do not want to see a wind farm in the Glendia area just north of Clacton-on-Ben. So I appreciate that that's not being dealt with by this inquiry, but I think it's important for the council to demonstrate that we're not just generally supporting wind farms, and particularly not the one for Glendia. Our primary concern over Fetteresso still relates to the turbine heights. 4 of the turbines proposed over 150 meters, so quite a bit higher than the existing mid-hill ones. And I understand now that 2 of those will have aviation lights on them. So for reasons of visual amenity, light pollution, noise pollution, and particularly to avoid setting a precedent for large turbines in this area, Fuchside Community Council strongly prefers for all turbines to remain below 150 meters now and in future, and this applies to Mid-Hill also. In some respects, I've not been able to understand what we're asking for here. I have asked them twice, but Fred Olsen have not answered my question: by how much will the average power generated reduce if the turbine height is limited to 150 meters? Mr. Denny said it would drop off a great deal, and I may have missed an answer elsewhere in the hearing, but perhaps if the reporter asked that question directly, he may get a better response than I did. The lights on turbines 7 and 10 at 2,000 candelers. I did listen again to Mr. Denny's explanation on how the intensity drops off as the angle from the light to the observer reduces below the horizontal. But I'll confess I'm still confused over how the car brake lights analogy helps with the understanding of those lights. And I remain concerned that these lights will be bad news for those hoping to view the Milky Way or the Northern Lights from observation points like Curloch or Mullock Hill or Clacton-on-Ben. We did make other points in our hearing statements, which I won't repeat in full. We've had some constructive discussions with Fetteresso Wind. We know they share our views over many of them, and we look forward to working together if the development goes ahead. For the record, I'll just quickly give you some headings of what's in the inquiry statement. Regarding power cables, we strongly prefer all cables to be routed underground. Regarding the borrow pits and other temporarily damaged areas, we expect them to be appropriately reinstated and revegetated. We will work with the applicant and with Forest and Land Scotland to explore the potential to enhance the tracks and paths around the wind farm for recreational use. And we note and support the applicant's commitment to maximise local content. And finally, we encourage the applicant to adopt a clear and sustainable approach to the life cycle and the Fetteresso development, particularly with regard to the sustainability of construction materials and waste management. And that concludes our statement. I went through it fairly quickly, but I hope it was clear.
Yes, very clear, Mr. Cleffam. So thank you very much for that. Mr. Innes, as best as you can at this stage, I wonder if you're able to respond to Mr. Cleffam and the points that he's raised in his statement.
Yes, Thomas Barkin. In terms of a detailed power assessment of a 150 turbine in the locations where we currently propose 180 and 200, we don't have the data. In terms of the evidence before the inquiry, you have, of course, the evidence that we went through in some detail about the iterations of Fetteresso as Mid-Hill. And you may recall that in re-examining Mr. Denny, I took him to a specific drawing which showed the relative wind resource on site. And within that particular chapter of the formulation of the Mid-Hill scheme, it disclosed effectively that the locations where the current taller turbines are was the lesser wind resource. And I suppose, I think one of the questions about this is that it's all about the relative heights of the turbines to the wind resource. And I think one of the helpful drawings that perhaps indicate how the different relationships between the turbines is possibly figure 4.5, which is document CD 1.12.6.
Sorry, gonna need to give me a chance now, because I'd say that was one of the features of the inquiry. You guys are so quick at finding these documents, it takes me much longer. So if you just give me a few seconds.
I don't agree with that. I think we've all struggled a bit when we're on the computer trying to find that. So
Okay, well,
so I'm just going now to the core documents list. So give me the number again.
1.12.6.
1.12.6. Right, I'm just opening it up now. Yeah, it's open now. Yes, okay, I can see that. That's the with the figure 4.5.
Yes, and I think that as I understand it, that ZTV is one which essentially tried to bring together an understanding of the extent to which the visibility of the scheme elsewhere in the wider landscape is being influenced by different tip heights. And I think what this largely discloses, if we're seeing blue or pink, these colorations are always difficult because you'll see slightly different things on screen. To me, it looks pink, but it could look almost purpley. But the pink and the purple, sorry, the blue and the purple are effectively those areas within the ZTV where there is theoretical visibility of the 180 and 200 meter tips only. So effectively what this at a generic level is able to say is it the height of turbines that's driving the visibility of the wind farm in the wider landscape, and to what extent is that occurring? And I think what this particular diagram illustrates quite effectively is that actually it's not the 180 or 200s that are driving the visibility. It's actually most of the visibility is green or light green or yellow. The reason for that is because the taller turbines have been located to the south on the lower elevation, and effectively what the taller turbines are being used for is to essentially get the turbines up to an elevation where they're equivalent of the other turbines on the higher ground. And I think that's really, that depiction shows this very well. So it's the taller turbines are not driving wider visibility of the scheme. They are trying, as I say, to match that height. And I think that's a matter, whilst I've pointed this out, it's really a matter more for Mr. Denny's expertise than mine. But I'm just pointing out that's where we come from. In terms of wind resource, I think there's another point that I think is quite important to make, is that it's a point that we sort of made yesterday about prior to 2015, when you were developing a wind farm, either of a fit or rock scheme, you had a fair degree of certainty as to what the income would be relative to the energy yield, in the sense of rocks gave you a guaranteed position, and together you'd also be able to sell the electricity. So you combine the two, and you have a very clear forward visibility about projected income. As the onshore wind farm statement identifies, The issue that we have at the moment is there is no such scheme. We're either in the open market or bidding in as low as possible to pots in the CFD auction round. So what's that doing is it's meaning that in producing schemes, we have to make them as effective as we can to have the potential to either be brought forward in the commercial sphere or alternatively to be brought into the effectively the auction sphere. But until we know where the strike price ends up in the auction, we don't know whether we've effectively done that or not. So in terms of trying to create really efficient schemes, it is very important that the wind turbines are located in a manner that's efficient. And as we identified when we went through the design chapter, that was a very specific consideration in the design of this particular scheme, but also making sure that where the larger turbines were located, that it took account of topography. So that effectively it tried to take them to the same level of wind in height terms than the other proposed turbines and the existing mid-hill. And that will probably reflect itself if you look at that original mid-hill ES with the low wind resource. That's all done at 45 meters above the particular locations. So effectively what we're going is higher to capture the better wind resource. So we're managing that. If you see the topographical difference in that, in essence, that results in the height at which the turbines sit in the landscape, and this is the resource that's trying to be captured. So as you go down in lower topography, to get the same wind resource, you have to go up to reflect that. And that was part of the design philosophy. I think I should probably hand over to Mr. Denny to perhaps respond on any of the landscape and visual mapping.
Yeah, there's probably a couple of things that I can help with, Mr. Clapham, in terms of, you pointed out what I said about, in my evidence the other day on Monday, about the potential power generation dropping off as the turbine heights reduced, and also, of course, as the swept path subsequently reduced as well. The reason for that isn't just about the fact that there is a higher wind resource, or in fact, higher wind speeds with higher elevation turbines. But as you come closer towards the ground, as we all experience from going around day to day in the places that we live, you get turbulence within the air. That's obviously caused by drag from topography and drag from ground cover, including trees and forestry. And that causes gusting and turbulence. The turbines will generate more efficiently in a clean airflow, and turbulence reduces. This is outside my area of expertise, and I'll say this, but I've sat in enough design team meetings for wind farms and listened to the technical experts talking about this to be able to at least help you to this degree. So the cleaner the airflow, as well as the higher the wind speed, the greater the generating capacity of any given turbine is going to be. So in order to maximize the efficiency of turbines, best thing to do is to get them into a clean airflow and to reduce the potential for turbulence. You then have issues of wake, which is the opposite thing. Turbines themselves cause turbulence behind them because the blades themselves are causing turbulence to the airflow. So we also have to site the turbines so that they don't cause turbulence to each other, because that also causes drop off, which is why wind farm design is so complicated. But it is the case that as you bring the height of turbines down and the swept path down accordingly, then you are bringing them down into that area where there is a lower wind resource in terms of speed. There's a greater degree of turbulence caused by ground cover and topography. And that's what causes that drop-off in the potential power generation of the turbines. So if the turbines can be kept up into that clean, faster airflow, not only will the type of turbine you choose generate closer to its maximum potential capacity, but you won't have that capacity being reduced by that turbulence or reduction in wind speed. So that was the point I was trying to make the other day, but I don't have, and I'm afraid I can't help you with the mathematics of that drop-off in performance, other than I've been told, as I've tried to reduce the visual impact of turbines in design team meetings, just how much I'm reducing the potential power generation in trying to reduce that visual impact and bringing the turbine heights down. The other matter, more specifically, relating to the area that you represent in terms of your community council, the 2 turbines that are now being proposed to be lit are only now turbines 10 and 7. Turbine 10 is a 200-metre high turbine, turbine 7 is a 180-metre turbine. And although they are tall turbines, they are not set at the highest points within in the site. But they do obviously give rise to being the highest to up height in the site because they're tall turbines. I think viewpoint 6 is the viewpoint 6 is at Scolty Hill, which is a viewpoint which is within the area of your community council. From that viewpoint, you can see potentially, from the wireframes, you can see that you potentially see 3 turbines. None of those turbines are lit. And the visibility of the 2 turbines that are lit in terms of seeing those turbine lights is very largely going to be in that area to the east and southeast because of where they're located within the site. And the visibility of those 2 lit turbines within your community council area, it ranges largely from none to negligible.
Okay, thank you for that.
For your note, the viewpoint 6 is helpful to you in that regard in terms of representative of visibility from the community council area.
Mr. Cleffam, I don't know if you've got any follow-up questions that you'd like to ask, having heard what you have.
Yeah, I don't want to go into a prolonged ping pong here. I don't think that's very helpful at all. I'm sure you've heard my arguments. I have heard what both Mr. Innes and Mr. Denny have said about visual impact. I don't completely share this view that I'm just representing people, if you like, sitting in their homes. Of course, you know, we use the whole resource around here. We live in a beautiful part of the countryside, and we all like to move around that countryside in order to observe it. So I take your point about the visual impact, the lights, and certainly the precedent setting of these large turbines still concerns us. And I'm disappointed. I mean, I come from an oil field background, so I'm used to the idea of dealing with uncertainties, both in terms of the performance of an asset, about the cost of installing an asset, and of course the price of the product when we get to sell it. So I'm used to those kind of uncertainties, and I'm aware that, you know, you don't go ahead with a development unless you've done some economic modelling, which gives you an idea of, you know, how much it's going to cost and what the revenue stream is going to be. So I'm disappointed that Fred Olsen are unable to answer the question, by how much will the average power generated reduce if the turbine height is limited to 150 meters? I think that's enough from me. Thank you very much indeed.
Okay, thank you, Mr. Cleffam. Thank you very much. Mr. Burgoyne, would you like to either read out your statement or summarise your statement?
Yes, good morning, everybody. Unfortunately, my bandwidth doesn't facilitate video. You'll have a choice of me speaking or watching me. So we'll go with speaking. So I just want to give a process check of how I'm going to approach this. Firstly, I'm gonna go through my thoughts, etc. Then I've had some questions from Mr. Denny and Mr. Innes, and then I will read out statements from the residents who are unable to join for numerous reasons. So I've participated in the first 2 mornings, and I have to say I'm extremely disappointed, shocked, appalled that I haven't heard one mention of the impact to the residents and communities within an immediate distance of the proposal. By your own information, Natural Power, Fred Olsen, whoever, there are 29 properties and businesses within 3 kilometres. Not one person has mentioned the impact to those people. We hear about Drumlithie, we hear about other areas, Strawn and so forth, but a lot of us are going to live within the umbrella of this proposal. Now, I'll get down off my high horse at that point, and I just want to set the scene a bit. Can I ask if anybody on the call currently resides within 5 kilometers of 41 wind turbines? I'll take that answer as a no. Is there anybody on the call that resides within 2.5 kilometers of 10 new proposed wind turbines? Again, I'll take that silence as no. So the information that I'm going to convey today, or my views and comments, are based on real experiences and not on guide standards and design practices, etc. My position quite clearly is that this proposal and any future proposals within the Mid-Hill area need to be rejected. My family and I moved to the hamlet of Chapelton 13 years ago, well, over 13 years ago now. And since arriving in this rural community, 41 wind turbines have been constructed within 5 kilometers of my home, with many more now operating east towards Stonehaven and south towards Lawrencekirk. In fact, I am now in the unenviable position where I can see and hear wind turbines to the north, south, and east elevations of my property, with even more under consideration, these 10 and the 2 that have just been approved on Hershey Hill. However, I would add that at this point, I'm clearly not an advocate of the NIMBY, not in my backyard mentality. I did not object to Mid-Hill Phase 1 and 2, it should be noted, even though they are in close proximity of my property. Now, the new proposal for the 10 wind turbines at the Fetteresso, wind farm, or let's just call it Mid-Hill Phase 3, as you're connecting into the grid through the same point, will obviously have an impact on my property, my family, my life, and that of my residents, and that of residents. Our concern is not only the 10, but the fact that they are taller than those currently operating the wind turbines that is operating at Mid-Hill Phase 1 and 3. Indeed, on inquiring as to why the proposed development included for even taller wind turbines, the representative at a town hall in Ockham Bay advised that it was purely a financial decision based on the loss of government renewable subsidies. So just to go back to that question, I think that Ross asked, clearly the lives of local residents, wildlife, and the rural landscape seems to be valued less than the profits of Fred Olsen Renewables. When Mid-Hill Phase 1 wind farm was originally approved, strict restrictions were established relating to the visual impact, the number of turbines, and the height aspects. In subsequent years, the site has been subject to a second extension, and it is now clear that the original restrictions have been ignored in the pursuit of profit. At this point, I would note that I am concerned that should this proposed development be approved, we will likely suffer further extension proposals, especially given that Fred Olsen Renewables has confirmed it is investigating a site west of Mid-Hill Phase 1. Whilst I'm a firm believer in renewable forms of energy and appreciate that we as a nation need to establish a greener, more diverse energy portfolio, I feel this proposal is inappropriate for the following reasons. Now, I'm not going to go through all of these in detail, but I'm going to highlight on what I think are the 2 main concerns. The visual impact, which is what we've been here for the last few days. Living in the hamlet of Chapelton, my family and I have clear, open views of the proposed 10 turbines. Indeed, as stated in Appendix 8, Residential Visual Amenity Assessment, the visual impact at my property and that of 11 other properties have been deemed major and significant. The actual quote from section A8.8.52 P7.2 reference a two-story attached property orientated southwest and northwest. The property lies some 2.5 kilometers southeast of the existing Mid-Hill wind farm. Section A8.8.56 states, overall for residents of this dwelling considered to be of high sensitivity, the magnitude of change would be substantial, resulting in major visual effect, which is considered to be significant. They are your own words from Mr. Halliday. At this point, I would also like to add that the visual survey at my property and that of the residents was only conducted by chance. The chance being that Mr. Halliday was looking for one of the local viewpoints, stopped a local resident, Mr. Cole, asking for directions. They got into discussion, and it transpired that he was doing a visual survey for this proposed development. As a result of this, Mr. Cole asked him, Mr. Ken Halliday, to do a survey at his house. He then passed his details to me. I then contacted Mr. Halliday, who came out to me, who then did the residents nearby to me. So it was not planned for it to be done. I find that unbelievable. Okay, I'll skip through the next points, but I'm concerned about the shadow and flicker effect of these turbines, given they'll be within 2.5 kilometers of my home. I'm very concerned about the noise. We asked at the town hall in Auchenblay the Fred Olsen representative to do a noise survey at my property. Guess what? Never heard anything. Or other residents, I would add. The second part, if we want to talk about my concerns, is safety, health and safety. The local roads to me are neither designed or capable of sustaining heavy goods and abnormal loads associated with a project of this size. Now, I understand that I asked the question, where would the access be? And I was told quite clearly it would be the existing route through the Slug Road. However, during phase 2 construction, the access track that I live on, the private access track that I live on, a single track, was accessed by construction personnel, deliveries, heavy goods, materials, etc., at contravention of your planning application. This resulted daily in 2 shifts, 6 a.m., 6 p.m., of a number of cars deemed they were on a rally course driving up through the Forestry Commission to access the Mid-Hill construction site. As a result of this, I was unable, and that of my residents, to allow our children to play outside for fear of being knocked over. Indeed, there were 2 near misses that were recorded. I recorded with Mr. Tom Haley of Natural Power, of speeding workers nearly knocking over one of my neighbour's wife and their child. As a result of this, Fred Olsen erected speed signs, but still continue to use the access track. No matter what this inquiry deems, we will not accept or allow access to this route via our properties. We have to maintain this road. We have to live on this road. It is not an access route for any vehicles to the wind turbine. Even now, service vehicles go past our property to access Mid-Hill. I live and work from home, and I can see quite clearly out of my window the number of vans and cars, and I know there's only 5 properties beyond my house and the residents therein. One final comment I would add to that. After numerous discussions with Tom Haney, the resident engineer for Natural Power, during phase 2 construction, given the number of vehicles that had accessed our roads, we thought it not unreasonable to ask him to implement repairs. This was a multi-million-pound development, and Fred Olsen declined to implement any permanent fixed repairs, and instead they had a labourer dump a couple of bags of cold macadam in the odd pothole. I think that says it all about Fred Olsen and Natural Power and their respect for us, the residents. The detrimental impact upon residents in close proximity to this proposed development, such as those living in the hamlet of Chapelton and nearby communities, is totally unacceptable. We will suffer from noise pollution, the adverse effects of flicker, and over and above these two factors, the overwhelming visual impact of these additional 10 turbines. That will bring it to potentially 51 turbines within my local area. In summary, all renewable energy projects need to be systematically cited, and a balance needs to be achieved between the benefits of renewable energy and the wider population, and the detrimental impact to the local community. Before I go into questions, I would just add this. For most of you on this call, this is your job. Tomorrow you will submit another proposal, you'll participate in another inquiry. For the local residents like myself, this is reality 24/7. We will have to live with this development for the decades to come. Okay, that's the end of my statement. But what I would like to do is ask some questions, given what I heard Monday morning and yesterday, if I can. Mr. Denny first, please. There's a fascinating insight into wind turbine visuals that you gave, but you didn't give any reference to the considerations given to the local community or residents. As I've mentioned, I suggest this is extremely disappointing, given that we will have to live with this development for decades to come. You did mention something around the extensions and to an existing and the impact. And can I assure you that an extra 10 turbines will, in addition to those already at Millfield phase 1 and 2, will visually impact anyone that lives within 2.5 kilometers, whether or not there's already 33 or no turbines nearby.
Me to respond to that, Mr. Burgoyne.
Pardon?
Sorry, would you like me to respond to that? I wasn't sure whether you were asking me a question there, but I was offering to respond if you wish me to.
Yes, yeah, your observation should be appreciated. Thank you.
Yes, first thing, you did read a couple of passages from the residential amenity study. The first thing to say is that there is a detailed residential amenity study dealing with the properties within 3 kilometres, and then, as you quite rightly read out, those properties in which it was deemed that there would be a significant effect. And indeed, there's a significant effect on 1, 2, 3, 4, 5, 6, 7 properties, and a potential significant effect on 9 properties, significant effect and potential on 2 more. They're set out in detail in the residential amenity study. The landscape visual assessment and the environmental information also sets out assessment which the reporter has before him on the impact on settlement and communities. So all of that information is there, and it is there for the inspector to make his judgment. I think the reason why you may not have heard it being discussed, particularly in relation to my cross-examination on Monday, is because the council have not made an objection in relation to residential amenity. That doesn't mean that the information is not before the reporter and he won't take it fully into account in coming to his decision. And yes, you're also correct. The LVIA does detail that there will be some additional significant effects resulting from the proposed extension, and it sets out where those significant effects arise, and not just within 2.5 kilometres. It in fact sets out significant effects on character up to 5 kilometres, and in 1 or 2 cases for visual amenity at a greater distance than that. So again, the significant effects that would arise are set out in the document. The council, of course, has also set out its views on where those significant effects lies, and the inspector will bring his judgment to bear. And again, I can assure you, he will be taking all of those matters into consideration in his judgment. The only thing I would say is that, of course, you do have to realise that I'm not the arbiter of what's acceptable or not acceptable, but a significant effect in a landscape visual impact assessment is not necessarily an unacceptable effect. And what I was at pains to say on Monday was that those effects need to be taken forward into the planning balance, and the inspector has a whole range of difficult and complex matters to consider, and he will take them all together into that planning balance. So the identification of those significant effects is a matter he will consider, but the identification of a significant effect isn't automatically an unacceptable effect. Judgment needs to be brought to bear.
Yeah, and that's the process. And I guess it's just unfortunate on the 12 properties, mine included, that are within those boundaries.
And I didn't interrupt when you said, but and it's not relevant to the importer's decision, but I'll just say it to give you some comfort. I can see 3 turbines from my home. Unlike you, there are only 2 single 60-metre turbines and 1 single 40-metre turbine that I have a view of. But a developer did come forward with a large wind farm just 7 kilometres from my home. And I have to say to you that I did feel that as I'm somebody who acts on behalf of wind energy developers, I'd have no right to do anything other than support that proposal. And so I supported my local proposal, and it was actually turned down on residential amenities, so it didn't get built. But I too am not a NIMBY when it comes to wind energy developments, if that gives you any minor comfort.
Mr. Burgoyne, do you have any further questions, or would you like to read out the statement on behalf of Mr. Walker and Mr. Morley? Mr. Burgoyne, are you still with us?
Oh, yes, sorry. I hit mute on my headphones. Sorry.
I don't know if you want to ask any supplementary questions, or whether now would be an appropriate time for you to read out the correspondence that we have from Mr. Morley and Mr. Walker.
No, I do have some questions for Mr.
Okay,
Innes
well,
still.
please proceed. Yes, thank you.
Yeah. So, Mr. Innes, in relation to the impact to local residents, like myself, within 2.5 kilometres, what were the consideration and the priorities of the design team, if any?
It's quite difficult for me because all I can refer you to is the environmental statement. I think, to be very clear, the formulation of a wind farm proposal involves a large number of experts, and what the developer will do, they will instruct them to prepare for a constraint map. So, for example, in noise terms, one of the first things that will be done is to understand the nature and extent of any noise, to understand compliance, because that's a constraint, a hard constraint in terms of noise compliance with relevant guidance and limits. And equally, in terms of understanding, there'll be a range of other factors that are all taken into account in that iterative design process. So we'll have the hydrologists, the people that are involved in undertaking the peat surveys. You'll have people understanding ecological surveys, and all that information has to get pulled together. And also, when they're considering the technologies and also the visualization. So throughout the process, the consideration will be given to matters such as using people like Mr. Denny's experience and his predecessor in terms of the scheme, using visual material to understand where the turbines can be seen from, and residential receptors are considered a key part of that process. If a wind farm gets too close to residential receptors, then that is a matter which will be very carefully analysed in the residential amenity survey. So in that context, we or the developer has to take all those factors and ensuring that a wind farm that comes forward has taken all these into account. And then it has to be reported in a structured fashion as to what the anticipated likely effects are on various receptors, including residential receptors, whether it be from noise, from the the visual aspects, and all those are very carefully considered and evaluated as part of the design process. And they also have to be formulated in the environmental statement or the EIA report now. And where there are significant effects, we've got to consider how we can mitigate them. So there is a very structured process, which, if I'll say, in terms of wind farm development, probably gets much greater focus than other forms of development. So, for example, if you're doing a housing development next to another set of houses, do they go to the same depths to understand and context? No. The primary focus will be on the development of the site itself. So, absolutely, there are very key considerations given to how a wind farm is designed relative to the receptors in and around it. And those are all factors that are weighed carefully in the design process.
So in relation to the 12 properties that are deemed significantly impacted, mine included, can you give me some examples of the mitigations that the design team actually implemented?
That's a visual matter which I'll hand to Mr. Denny.
Yes, I can tell you how the process is from my input and that of Mr. Halliday. And by the way, Mr. Ken Halliday is a very, very experienced landscape architect. So you did have a very senior and very experienced landscape architect come to your property and undertake an evaluation. But when either a landscape architect like myself or Mr. Halliday are advising on wind farm design, we have a duty within the design team to try to see how we can appropriately minimize the environmental effects from the landscape perspective. That's character, visual and residential amenity effects, whilst allowing the rest of the team to balance that against their desire to produce renewable energy. As I said, it's always a balance. When it comes to residential amenity, it's a very difficult area. It's been a long-held principle in planning that there's no right to a view. So, for example, if I'm working on a new housing development and somebody currently has a house and has lived in it for 30 years that has views out over lovely meadows, and the local authority has granted permission for that to be developed for housing, then that person can lose their view completely, can look from at a mere distance of 20 metres into the rear of another new property. And that is not an unacceptable change in relation to their residential amenity. And residential amenity is quite complex and has a number of facets. Housing, for example, it might be overlooking or privacy or loss of light, certainly noise and disturbance. With wind energy, the three primary elements of residential amenity tend to be visual, noise, and as you said earlier, shadow flicker. And that's largely because the distance the turbines are away. From my perspective, one wants to make sure, if possible, that there are not significant effects on properties if the mitigation will allow that, balancing that out against all other factors. It's extremely difficult with a commercial scale wind farm in the United Kingdom, even in the larger open spaces that Scotland has available, for there not to be significant changes in views on properties when wind farms are located in the landscape. What we don't want to do is impact on somebody's residential amenity to such a degree that that becomes unacceptable, considered unacceptable in the planning balance. Part of that process, once we've identified that there is a significant effect on a property, the judgment we have to make as to whether we think that the nature and context of that significant effect is such that it might be deemed to be overwhelming or overbearing on your residential amenity. Because then that might be a factor that the importer would consider could lead him to a decision of unacceptability in relation to that impact. None of the judgments in relation to these significant effects were deemed to be overwhelming, overbearing because of the context and the distance that the turbines are away from the properties, notwithstanding the fact that there is that significant visual change. And again, I come back to that point of view, and I fully understand your position. You don't want the view from your property to change negatively, but a negative change in the view from somebody's property doesn't automatically equate to an unacceptable impact in relation to residential amenity.
Thank you. But what I actually asked was, could you give me details of where your design team implemented changes to the design to reduce the impact to mine and 11 other properties?
Yes, the design iteration process, as it would have gone through with the design team, would have looked at what the impacts of turbines in particular locations and at particular heights and in particular configurations had on all the facets that are being considered. Heat, water courses, landscape and visual effects, ecology, ornithology, all of those things will be examined in relation to what those design iterations had. And if there were some turbines in part of that design iteration that the landscape architect thought were giving rise to too great an impact on a residential property, such that there was a danger that that might be deemed to be overwhelming, overbearing, they certainly would bring that forward within the design team meeting and say, look, we need to reduce the impact of this turbine on this property because otherwise we're going to be in that very difficult situation of potentially overwhelming, overbearing. That discussion happens as the design iteration of wind farms evolves, because of course it is not in the interests, certainly not of the local residents, the local community, but it's not in the interest of the developer for a turbine to be judged to be unacceptable in that regard. So they don't want to bring forward a scheme that has that level of acceptability or potential acceptability attached to it. So it is always a consideration in the design of a wind farm.
Okay, let me ask you the question differently then. Let's be clear. I'll go back to the opening statement that I did not object to Mid-Hill Phase 1 and 2. Okay, even though I can see them from our windows. I'd like to know then that what considerations were given to the local residents in the design of moving turbines T4, 5, 6, 7, 8, 9, 10 closer to the community than Mid-Hill Phase 1 and 2, as opposed to northerly, westerly, easterly. The only way you moved closer to the residents was to move to the south, which you've done.
Yes, it is what I said to you. I mean, I can't speak for Mr. Halliday, but I can only speak for the process. The process will have been, well, the location of turbines in this location will give rise to some potential significant effects on local properties, and then that will be analysed. I'm afraid it isn't the case that if a significant effect is likely or is identified during the process, that automatically will lead to them saying, well, we can't proceed with turbines in this location because there is a significant effect. Because turbines, I'm afraid, do give rise to significant effects. I'm telling you that it would have been a consideration, but I'm afraid that consideration isn't one where necessarily the design team will eradicate those significant effects, because that could be to impoverish the design such that it isn't an optimum for the site. So unfortunately, and I've said I understand your position, it still is the case that a wind farm will come forward with the potential for some significant effects on residential properties, notwithstanding that the design mitigation process that's been undertaken, because it will be part of achieving that overall balance within the wind farm. But I can tell you that where it is possible within a scheme to reduce those effects and still come forward with a viable scheme, then that will be done and will be looked at. But it doesn't mean that a scheme will only come forward when the design team has decided to eradicate all significant effects on views from properties, because that may render most wind farms unviable.
Mr. Innes, as I've explained, the lack of consultation from Fred Olsen, would it have been reasonable for the developer to consult the residents directly impacted by the proposed development directly?
All I can say, sir, in response to Mr. McGowan, is that there are formal processes for engagement, and I know that that this client takes those particular aspects very seriously. They've held events, they've listened to responses. That is part of the way in which they operate. You may not like the outcome of that process, but there has been a formal process of consultation, and that has been gone through in this instance. The difficulty with what you suggest is that sending people out to everybody's house is not what everyone wants. You may say, I might have wanted somebody to come and knock on my door. There's plenty of other people that do not want developers knocking at their door and find that an invasion of privacy. So effectively, there will often be contact in a wind farm context to enable, if allowed, to do the residential amenity survey because there's no right to go onto people's property to do it. And in circumstances where consent is not given for that property to be assessed in a detailed fashion, the best that they can do is go to the nearest publicly available location and carry out that assessment. So in terms of actually going out and meeting every single person, as I say, that is not, in my experience, what happens. And I don't think it would necessarily be appropriate purely on a consultation basis to do so, because there are formal processes for consultation which should be undertaken properly and fairly in circumstances where people can come and engage with the developer. And that is a standard part of the process of development proposals. And equally, it means that they'll have often a number of experts available at such events to be able to answer questions. Now, would you be happy if I turned up with 3 or 4 different people to come and have a chat about the noise, the landscape and visual, and the transport? I just think your perception that it would be nice to have something to knock on your door is not one that would be shared. And therefore, normally what happens is there'll be events, and I fully appreciate that in the context of COVID, some of those events have had to take place elsewhere, but examination and discussion and input is a key part of the process. And equally, you'll have seen through community councils or another forum in which engagement happens and which there is ongoing dialogue. And all I can say is my experience of working with this particular developer is that I think they do everything they can to engage with people who want to engage with them. So I don't agree. And you did criticise the applicant's parent in relation to certain matters. My understanding in relation to that construction process is that there were some construction workers who were housed during that process locally who were using that particular access back up to the wind farm development site. The complaints were noted and the alterations did take place after the complaint had occurred. In terms of the operational site, the only use of the access, as I understand it, that's authorised in the protocols for the site, is in an emergency circumstance, which I'm sure you would accept that in circumstances where there may be an emergency, that it would be potentially appropriate to use the safest and most convenient exit from the site. And this does afford that in circumstances. In terms of how that's managed going forward, we're about to have a conditions session. And no doubt the point that you make there is a matter that we can take forward. And I just want to perhaps extend that in that context, one of the things that I think is developing as part of better practice is to have more direct contact with people that want to have contact during the construction process, and to ensure that there are appropriate telephone numbers and other things that can be raised, means of communication, to ensure that the effective communication can occur during the construction process. And I just said that is increasingly becoming a standard part of that whole process. If I was saying not just involved in onshore but offshore wind in the onshore aspects as well, is ensuring that there is a proper means for members of the public who may either not have concerns or just want to find out what's happening, to be kept informed and also to have an engagement and an ability to be contacted. And certainly we can look at that in terms of the conditions. But my experience of these matters that were properly raised, these matters can be adequately dealt with, and there can be formal processes and transport management plans to ensure that these matters are properly and fully dealt with in terms of a process of condition and plan.
You raise a number of points there, and I'll address them in the order that you came back to me with. Firstly, the pre-meetings were pre-COVID, so that has no relevance on this discussion. Secondly, the 12 properties that were identified as having significant major impact, 6 of my asked for visits, asked for one-to-one discussions. So I'm not expecting you to knock on the door, but when I ask for a visit, I would like to have a visit. We have still not had any noise meter tests done. As I said to you in the opening, it was sheer luck on our perspective that Mr. Halliday came knocking on somebody else's door looking for somewhere. Otherwise, he advised to Mr. Cole that he wasn't down to even come to the 12 properties that were identified. 12 properties. I reiterate again, 12 properties. It's not difficult when 6 of those property owners reach out and ask for further information, further investigation, further surveys, further dialogue. In my business, if there's issues, I would speak to those people. They may not like the outcome, I agree, but you give them a platform to discuss things with. Genuinely, you can come to agreement or disagree, but silence and a lack of respect generates the situation that we're in now in terms of myself and the other residents' dismay with dealing with Fred Olsen because you don't deal with us. You won't talk to us. Access. The local jobs that Fred Olsen generated for Siemens and for Jones Brothers Civil Engineering Contractors from Wales, indeed, they resided in caravan parks at Fordham and other places locally. That still did not justify them taking a shortcut past our properties to access the development site. In addition, I can absolutely assure you that there were deliveries that went up past our house. I lived there. I saw them. Couriers, cement lorries. The secretary used to park outside my neighbour's house and be picked up. Examples. When I approached Mr. Haney and advised him of the 2 near misses, nothing changed. He put some signs up. The traffic still flowed. Speeds were still exceeded. The noise, the rubbish, it made living here horrendous. I moved to the country for peace and quiet. I did not move to the country to have 2 shifts on a rally track coming past my house. So yes, it is a condition, and I've talked to the reporter when he had the visit. And the 2 near misses, I trust that the health and safety is first on your list of priorities. Am I correct? That's a question.
Well, I'm not a transport expert, but I think
Is the health and safety of the residents and my children, is that the first, should that be the first priority for any future development in terms of access for the development?
That's a matter for Transport Services of Aberdeenshire Council
No, it's a private road. It's a private road, so they have no jurisdiction.
Okay. Mr. Burgoyne, I've got your written statement here. You've made your point quite clear. And when we met on site, again, you made your point quite clear. And we've had a discussion here. I'm not sure we can take this matter much further. As Mr. Innes said, we do have a session later on today where we'll discuss conditions. And obviously there's an issue with the enforcement of previous conditions, perhaps in respect of the Mid-Hill scheme. And we can certainly address that and perhaps look at the wording of any condition that might address the use of that track. So I think I've got enough. I fully understand and appreciate your concern. I've got it here. Although we haven't had a session in general terms to talk about transport, I will address these matters in my reports. So just because we haven't aired these issues in the forum of this examination, my report will address these matters, and I will address the specific points that you raise in your submission on a range of topics that in my report. So please don't think that they're not being acknowledged or listened to or addressed, because they certainly will be.
That's fine. I was just responding to some information that wasn't strictly correct. Let's put it that way, from real experience. Okay, so now I have statements from 2 local residents. The first one is Nick Walker. He lives in Cosbold Cottage. He will reside in what will be potentially the closest property to the development. Oh, coincidentally, he starts off, so I'll read this verbatim. As the closest inhabited property to the proposed Mid-Hill wind farm extension, I have serious concerns on both a general level as well as regards specific. So this is not my English. The overriding concern is the total lack of communication information from the developers. I think I've already touched on that point. Several years ago, I attended the public meeting in Auchenblay Village Hall when the idea was first mooted. As a result of that meeting, a representative visited me with some computer-generated graphics of the proposed development and photographs of my property taken. Sadly, that was the last time communications were established by the developers. Many months later, I discovered by chance that a further meeting was being held in the village hall, and despite it being late in the day, I immediately attended. There I received an apology for not being informed about the meeting. I promised that I would be kept informed in the future, and the website address for all the documents were filed. That was the last time I had any communications with the developer. On returning home, I spent many hours going through the documents filed. The first observation was that whilst it was claimed my house was outside the prescribed distance from the nearest proposed turbine, from memory 10 times by the height of the turbine. Unfortunately, I've updated my computer and so no longer have access to the website address to check. This was a cause of creative measurement. Sorry, I'm reading it. It doesn't read well to me. Strictly speaking, the house itself is just and only just outside the boundary. Part of my garden lies within it. The second thing noted, and more seriously, in one of the documents filed, the developer states that the work involved would have a significant effect on the water supply to my property. The consequence of this would make my house uninhabitable, and no timescale was given for the disruption or whether it would be temporary or permanent. Despite knowing this, the developers have not informed me of this. No discussion has been had regarding it or anything else. I have concerns also about the possible effects of the flicker from the turbine blades. Most of my time at home is spent outside for my hobby, and the flicker at certain times of the year is likely which would curtail my activities. Sorry, I'm reading it verbatim. My major concern once the wind farm is operational is noise. Having lived here for approximately 40 years, one of the main factors in purchasing the property was the peace and quiet. The existing wind farm occasionally produces noise or people outside, but is rarely obtrusive. The proposed extension of larger and more importantly closer turbines will have a significant detrimental effect. Noise and potential dust is also a concern during the construction phase. Problems were encountered during the initial construction with traffic and disturbances from the construction workers. My biggest concerns are obviously the possibility of being forced from my house due to the lack of water due to the developer's operations, and the noise during both the construction and operational stages of the proposed extension. It is entirely possible that most, if not all, of the above concerns can be addressed, but not with discussion and dialogue. Past performance on the part of the developer inspires no trust. The developer makes a lot of noise about supporting local communities, but ignores people directly affected by their schemes. Giving money to communities 7 kilometers from the site does not help those who live with the consequences of their commercial operations every day. Nick Walker, Cosbold Cottage. I think some of that I had also reiterated perhaps in different language and context. Okay, Dave Morley is the farmer and owner of the track and proprietor at Chapelton Farm. And I'll read this verbatim as well. It's not quite as long, thankfully. I would like to draw your attention to the following concerns I have regarding the proposed wind farm extension at on Glenfacker Hills. That's the name of the hills near us, I would add. Firstly, I'm worried about losing a supply of water from my farm from a spring rising on the hill above my farm, as the turbine and borer pit are to be constructed on the opposite side of the hill. Any blasting for quarry purposes could shift the water to the opposite side and my water would be gone. Secondly, I had a visit from a representative of the developers around 2 years ago concerning phase 3 and asked for a noise meter to be erected to ascertain existing noise levels. I've heard no more in response to this request. Same as myself. I also asked for information about flicker being as to the height of the proposed turbines. Being as I was left in ignorance, I get annoyed when the developer talks to people 4 miles away or more in village halls, when people whose day-to-day lives living under them are ignored in the pursuit of general agreement by the masses. Thirdly, the farm track running through Chapelton and being in the ownership of Chapelton Farm raises the following concerns. The track is a single right of access to the houses and farm properties, and a prescription of right is agreed with the Forest Commission for the extraction of timber only. We emphasise only. During the last phase of the turbine development some 7 years ago, the use of the farm track got congested, to say the least, to the detriment of the householders. As I have reiterated, at least 2 near misses regarding pedestrians were recorded, again, as I've noted. Thank goodness there were near misses. I do not know how I would have stood with my farm insurance policy, re public liability. I would therefore insist that no works, traffic access to farm track and the road end is signposted to this effect. And he goes on to mention, as you stated, Mr. Innes, but in the event that an accident on site occurs, then an exception is granted for 999 emergency responses only. End of Dave Morley's statement. So you can see myself, Mr. Morley, Mr. Walker, Mr. McLeod, who's unfortunately offshore at Cotter House, Mr. Kilford, who's unable to attend today from 3 Chapelton Steadings, and Mr. Cole from Forestry Commission. So that's 6 of the 12 properties. We all have exactly the same concerns about the development, the traffic, and in case of the 2 residents that are close to their water supply, etc. That is the end of my comments, feedback.
Okay, thank you, Mr. Burgoyne. Mr. Innes, I don't see anything particularly want to say in response to the statements that Mr. Burgoyne read out in respect to Mr. Walker and Mr. Morley.
I'll be brief, sir. In terms of water, private water supplies, they have been assessed in the environmental statement. I think the comments that are made may well be in the relation to the initial exercise on potentially identifying private water supplies that might be affected. And that will often say, is there the potential for a significant effect on a particular receptor? There's then further work undertaken and consideration given to mitigation, and the residual effects are not significant as far as the findings of the EIA are concerned. So I think it is quite important not to just extract the initial sift of saying, should this be assessed? And they will consider that on a worst case basis without mitigation, and then proceed to then assess it and find and assess the potential effects. So that is undertaken in the environmental impact assessment report in chapter 10 and appendix 10.6. I think what is quite helpful is the comments made about the noise. And I think that is quite helpful, because as I understand it, the comment made about noise, the current productions at Coalsbold in terms of the existing Midhill 1 is 32 dB, Midhill 2 31. And so what we know from the that current operation is occasionally audible, but does not appear to cause the resident any particular disquiet. The Fetteresso equivalent is 33.
Yep, I've noted it, and I'll feed that back to Nick. I'm sure he can sleep easy knowing that. Thanks.
And if I may say that one of the reasons probably as to why noise measurements weren't taken is that it was based on having looked at what the levels of were predicted, they were sufficiently low that the fixed limits would meet them, and it would still be within the fixed limits of the original mid-hill schemes. And we'll obviously come and talk about the noise condition in due course. So I think it is useful to understand that in the context of the current scheme with those levels of noise, that does not appear to be causing any particular issues, although acknowledging that in certain wind speeds that they may be heard. But that's not something that we claim.
Wind direction is the main driver. Just one thing on that question: were those measurements and forecasts, were they based projected with the tree coverage as is, or without the trees? Because the trees, the forestry is a crop, of course, and the crop is regularly harvested, maybe not annually, of course, maybe every 20, 30 years. Was it taken with the trees being present or not being present?
The trees being present would not alter the predictions of noise. That is not a factor that is taken into account in the noise predictions.
So it's not taken into. account.
It's not seen in noise terms, even if you've got a screen of trees. Whilst in practice, it may, for the purposes of this type of assessment, no, because you've got noise spreading down from the hub height, coming down from it, and therefore it would be entirely wrong. And in general terms, unless an acoustic barrier is to a British standard, you will not be taking that into account in terms of arguing that it's a mitigation to noise matters. So no, absolutely not. It would not take that into account at all.
Just one, as neither of them are here and are very, very, very concerned about the water supply. Is there, and this is perhaps for the reporter and maybe for the planning if they're here, is this a condition that can be applied, that they will not lose their water supply, if that makes sense?
Well, as Mr. Innes has said, the application supported by an environmental impact report and private water supplies is addressed. I think one of the conditions that we may discuss this afternoon is about the submission of a construction method statement. And within that context, I think the applicant would have to demonstrate that they've safeguarded and the proposal wouldn't have any undue effects on private water supplies. So if the application was to receive consent, then that would be a condition of consent, and that would be for the council to discharge once they're satisfied that the information that's been provided, is acceptable.
Okay, I can understand it, but in layman's terms, I can't
Yes.
I can't. Yes, thank you. I need to tell them. Will they lose their water? If it goes ahead, will they lose their water? Yes or no? I need to tell them that they will not lose their water supply.
Okay. Well, it's a matter that we'll discuss this afternoon, and the planning authorities have the ability to impose conditions to ensure that that wouldn't necessarily be that wouldn't be the case. So it will be addressed.
Thank you.
Okay. So is that you finished, Mr. Burgoyne?
Yes.
Well, thank you very much for your participation in the inquiry. Thank you very much. Okay.
Pleasure.
Okay. It's 10 to 11. I don't know how long you intend to take to present your evidence, Mr. Strawn. I wonder if it might be appropriate to take a break now and then for you to start after we've had a short break. Mr. Innes, I don't know if you feel that would be appropriate, or
A cup of tea would be gratefully received. So yes, I think a short break.
Okay, Mr. Strong, would you mind if we have a short break and then afterwards we'll hear directly from you?
Yes, absolutely.
Okay, thank you. Let's break for 10 minutes. Thank you. Okay, I think we have everybody back from the break. Mr. Strawn, in your own time, would you like to present your evidence, please?
Thank you very much. I've had a few difficulties with connections today. I kept on breaking out, so I'm afraid I missed quite a bit of the discussion earlier on. I must admit there has been times when it's felt like there's just a few old men all sort of asking to sort of, you know, can you hear me? Can you hear me? Can you hear me? So I'm a little concerned about that with the inquiry of an industrial project of this magnitude that that we should be having to all the time. But I think you'll have gathered whether you've got the evidence that you need. So I'm going to just read a statement which I've written last night. If I refer to Strawn and Strachan, you'll know what I mean. I mean Strawn or Strachan, which is spelt the same way. The village is pronounced Strawn, but people in Scotland, mostly 90% pronounce Strachan, and throughout the world, it's probably 90% call themselves Strawn throughout the world. And there's reasons for this, but I won't go into them now.
Okay.
So, my name is Rob Strawn. Firstly, I'm here today representing myself as a business relying on tourism from this area. The Fuchside Guest House, recently acquired by Clan Strawn, in an international fundraising effort to create a centre for heritage, shows that Clan Strawn are serious about their commitment to this area of Aberdeenshire. This year, although I have started late due to the various lockdown restrictions, I've still had well over 200 visitors for bed and breakfast from Israel, the Netherlands, France, Spain, USA, as well as from the UK. Just to mention a few of the countries. All have expressed their joy at our unspoiled landscape, and a large proportion were pursuing outdoor pursuits, including hill walking, canoeing, cycling, horse riding, and competitive sports. They have all been enjoying the many viewpoints throughout this area. I'm hoping and expecting to grow this business a great deal more. The siting of such huge 200-metre turbines will have an enormous effect on the tourism which this landscape-situated guest house attracts. This I believe to be a material consideration. Secondly, I'm the chairman of Clan Strawn Charitable Trust, which is a Scottish charity regulated by OSCR. We are open to donations from overseas and at home in the furtherance of Clan Strawn ambitions for the future. The siting of further large turbines at Fetteresso will have a detrimental effect on attracting overseas investment to the trust. I believe this to be a material consideration. Thirdly, and primarily, I've been elected in 2014 to be commander of the Honourable Clan Strawn. As commander, I represent over 100,000 Strawns and Strachans from around the world who view this area of Aberdeenshire as our ancient homeland. We are not the same as many other clans, as since we were dispossessed over 700 years ago, we do not have castles or pictures of clan chiefs in the past to encourage and inform members of the clan. Instead, we look to the hills and include ancient sites such as Castle Hill in Strawn and Ninestane Stone Circle. Ninestane Stone Circle is approximately 3,500 years old, with a recumbent stone unique to northeast Scotland, and forms the basis of clan heritage and what the many thousands of Strawns and Strachans are looking for when they are searching for their ancient heritage. Ninestane Stone Circle is one of 3 stone circles situated very close to where planning is sought for the new turbines, the largest of which, with a span of the propeller blades, you can fit 2 jumbo jet 747 aeroplanes wingtip to wingtip within the span. There has been international outrage at Fred Olsen's renewables plans to site such large turbines so close to the ancient heritage which so many thousands of people aspire to, because these ancient stones prove that people lived in this area many thousands of years ago, and Strawns believe that we are descendants of these ancient peoples. I believe this to be a material consideration, because of the tens of thousands across the world that must visit the village of Strawn, their namesake, and the few ancient historical sites that we have to offer, which are set amongst the beautiful countryside. Having been elected by clan members from around the world in accordance with all due protocol, I have then been appointed by the Lord Lion Chief of Arms to the position of commander. I am duty-bound to serve the interests of the clan, and so it is incumbent on me to protect the heritage of the clan from industrial development of this nature. If the development goes ahead, it will seriously affect my ability to encourage Clan Strawn to visit this area of Aberdeenshire, because I rely on the beauty of the landscape which surrounds the village of Strawn to speak for itself and instill that sense of hope and longing which so many people talk to me about. The very foothills of the Cairn Gorms, this landscape area is a jewel in Aberdeenshire's crown. I support our council. Our council is elected by the people who live here. If our council creates special landscape areas, it does so having been democratically elected. They deserve our support, and they deserve the support of the Scottish Government. Scottish Government should defend our local government and defend local people from the unscrupulous, sustained attack of wind developers whose prime motive is profit, who seem determined to ruin the beautiful countryside that surrounds us, spoiling it for local people and the tourists and visitors on which so many livelihoods depend. Wind farm representatives, including lawyers, are employed by large companies who can afford to pay them to attempt to get them the results that they want. People who live in this area do not receive money to object to plans which wind developers create. So there is an inherent unfair playing field. Government needs to appreciate this more. As I understand it, original planning permission was granted for 25 turbines. There are now 33 turbines, and the wind developer wants to site another 10 and much larger turbines to make 43. Surely planning permission granted for 25 turbines should be just that. Not 33 or 43 or 53 or 63. It is disingenuous to the public as a whole to grant planning permission for a designated number of turbines, which can just be extended in subsequent years with little public consultation. In other words, once a wind farm has got their foot in the door, they can just keep pushing the door open. I've been listening to those involved in the inquiry over the last 2 days, and there are a number of comments I would like to make. There's been, over the last 2 days, a great deal of time spent on dissecting individual viewpoints, mostly as seen from the road. I was lucky enough to have the opportunity to ask Mr. Denny, employed by Fred Olson Renewables, I believe, how many viewpoints in Aberdeenshire he had identified or considered. He said 16. When I asked him how many he thought there were close to the proposed development in Aberdeenshire, he quite correctly said millions. So in this inquiry process, you have looked into 16 viewpoints and expect that to be representative of millions of viewpoints. This concentration by the inquiry into just a few viewpoints negates the overall dramatic effect that the new planned wind turbines would have on the overall landscape of this area as a whole, by reducing them to a small, manageable number, which can be dissected and argued over as to their relative merits. All very disingenuous and, in my opinion, calculated to produce the results the wind companies are looking for, namely uncertainty of visual landscape effect. The environmental impact assessment was paid for by the wind farm. As a matter for the Scottish Government looking into policy, and policy was discussed yesterday, how can the public at large be assured that an environmental impact assessment paid for by a wind farm will be objective? Everybody knows that a company or individual who is employed will try to give their employer what they want. If they do not give their employer what they want, they're unlikely to be employed. There's a clear conflict of interest here, and the government needs to look into this. At COP26 yesterday, the preservation of wetlands was seen as of the utmost high.
Oh dear, Mr. Strawn, you seem to have frozen. Callum, can I just ask if you could check if anything is wrong our end with the broadcast, or is it due to the poor connections that Mr. Strawn had mentioned earlier?
Yeah, I think it's the same problems he was having earlier. I've got the wee warning triangle just in the corner of his window, so maybe just a minute or two for him to reconnect or rejoin.
Okay, we'll just pause for a few moments then to allow him to reconnect. Thank you.
Hello?
Hello, Mr. Strawn.
Hello?
I'm afraid your the image is flickering. You're coming in and out.
Can you hear me?
We can certainly hear you. I wonder if you turned off your camera and we could just use the audio, whether that might help.
Can you hear me?
We can hear you a little.
Can you hear me?
Yes, but not particularly well. If you can hear me, Mr. Strawn, perhaps I could suggest that you log out and log back in again.
Hello, can you hear me now? Is that better?
Yes, that's
Okay,
much
okay, I've managed
clearer.
to
I think we got to the point where you were raising the issue about how objective an EIAR is when it's prepared by the developer.
I just said that there's a clear conflict of interest here and the government need to look into this. That's all I have to say on that.
Okay.
At COP26, that's the climate change in Glasgow. At COP26 yesterday, the preservation of wetlands was seen as of the utmost high priority. That includes all peat and not just deep peat. Mid Hill Wind Farm has been built on peat and should never have got planning permission in the first place. If perhaps it was known at the time what an important role peat plays in carbon storage. The huge significance of peat in carbon storage means that Mid Hill Wind Farm, as it stands, is likely to be releasing more carbon into the atmosphere than it is saving. I would like to quote a local resident and friend, Keith Mayer of Invery House, who says, and he's said he doesn't mind being quoted, "I am the ex-head of the Aberdeen office of FTSE 100 listed investment company 3i plc. As I see it, the key argument is that as offshore wind is now economic and attracting new wind farm investment without consumer subsidy, so we no longer need to tolerate the many environmental drawbacks of onshore wind. Onshore wind was a bridging technology to a greener future in the UK, whose time has now passed." He goes on to say, "The unrestricted space available offshore with turbines grouped in hundreds has enabled mass production and construction to drive down the installed cost per unit dramatically. The strike price or guaranteed price per megawatt hour of power delivered has tumbled from £120 a decade ago to circa £40 now." I would like to refer to Mr. Innes referred to the woods in Fetteresso and the surrounding landscape as conifer monoculture. I imagine to denigrate that aspect of landscape that it might appear more suitable for large-scale wind development. However, if the Scottish Government was really interested in climate change and really interested in carbon capture, it would have immediate effect create a thinning policy to create sustainable woodland. And I would just like to mention this about woodland because it's about carbon and about the turbines being such a great thing for carbon. To put it as simplistically as possible, and I have formerly been a tree surgeon and director of woodland, if you had planted trees, say of the quickest growing variety, in Mr. Innes' words, conifer monoculture, something like Sitka spruce, and left them for 25 to 30 years, if you thinned them after 30 years instead of clear felling them, which is the current practice in Scotland, in other words, if you could cut half of the trees down over a designated, say, 100 acre area, in a year's time, after the 30 years, you would have just the same amount of wood that you had in the previous year, because the trees expand to the increased light, the trees that remain. And you can do the same again. Take every other tree out in each subsequent year, and you will still have the monoculture woodland, though with larger and larger trees and the same amount of actual biomass wood that you started with in the first place. It gradually diminishes, but it takes time for that to happen. In the clearings, you can plant deciduous, such as oak trees, beech and fruit trees, which will grow more easily in the shelter of the conifer monoculture trees. This will create a more diverse woodland, encouraging more plants and increased habitat for animals as well. Surely this is the kind of landscape we should wish to create, whilst also saving and storing carbon. No need for wind turbines here to store carbon. putting up wind farms is destroying the environment in the name of the environment and is, quote, environmental tokenism. If anyone asks the government what they are doing for climate change, they can point to how many turbines have been built. It is a visible physical testament to what has been done to save the environment, whilst at the same time destroying the very environment they were supposed to save, whilst making large corporations very much richer. The argument that wind farm companies are giving, that huge 200-meter onshore turbines built on peatlands are now necessary and must be put somewhere in our Scottish landscapes urgently, are quite simply not true. The Scottish Green Party, of which I am a member, completely agrees with me and many others. Building wind farms on peatlands is completely counterproductive. There are also many other renewable alternatives out there, including tidal barrages, solar, and hydrogen from water, just to mention a few, who could play a much larger part in a necessary mix of renewable alternatives if they were just given a little investment. The Scottish Government should at least attempt to instigate this necessary mix of renewable energies. I very much hope that Scottish ministers will support our locally elected officials, that they will support our local tourism industry, that they will support the world-renowned dramatic beauty of Scotland in this part of Aberdeenshire and reject the application from the wind farm developer in this instance. Thank you very much.
Thank you, Mr. Strawn. Mr. Innes, I don't know if you wanted to respond to anything that you've heard from Mr. Strawn.
Perhaps a few very brief points.
Yeah.
Just to sort of perhaps put a couple of matters in context. First of all, dealing with the EIA, the Environmental Impact Assessment. The first is that it is a process whereby the developer prepares the document, but in terms of process, it'll often be preceded by a scoping request where they're told and guided how it's to be done. In terms of the regulations, they're obliged to employ professionals, disclose the full professional qualifications of those professionals, and to use experienced people that are capable of undertaking that assessment. Those individuals are all, as far as I'm aware, if you look at it, members of professional bodies. And the reason for having professional bodies is that they have duties. They have to follow their professional guidelines in undertaking their professional duties. And one of the matters in that respect is that an environmental statement is essentially a series of chapters prepared by professionals exercising professional judgment, appropriately having regard to their rules. And equally, there are very clear rules within the regulations about what's to be disclosed in the Environmental Impact Assessment Report, and very severe consequences for those that abuse it. So I think to suggest sorry, I'm just going to finish. To suggest the Environmental Impact Report is skewed in that fashion is suggesting that individuals are behaving unprofessionally, and that the rules in relation to the preparation of the Environmental Impact Report are not being followed.
Okay. Yes. Can I make a point there?
I'm just going to respond fully. And what the process is designed to do is to set out what the developer considers. They have to set out the workings as well. That's part of the whole process. So the methodology, the background information on which they've formulated the views is all disclosed. And then it is disclosed to professional, to consultation bodies who are effectively specialists in the field who review that information. So this environmental assessment will have been reviewed by SEPA, the Planning Authority, and all these people. And you, as a member of the public, can look at it as well and comment. And your comments are part on the environmental assessment process or part of that process. And simply put, there are lots of safeguards in the process, and it's designed to facilitate that you can access that information and participate in a process. So I don't accept just because a professional is employed by a particular developer that their professional duty is compromised merely by that employment. The rules require us to have professional people.
Okay. Can I answer? Return that. Wind farm companies can choose the companies who give the most favourable environmental impact assessment, or the most favourable to what their views are of an environmental impact assessment. They can choose those people. That's one point. The other point is that why can't then an environmental impact assessment be funded separately? Why can't it be? I mean, this is a democratic country. Why can't we? Why can't the public be assured of an independent environmental impact assessment not paid for by a developer who wants certain outcomes?
Okay, Mr. Strong, perhaps I could stop you there. There is broad agreement that the methodology that the applicant has used to prepare the EIAR is acceptable and conforms with standards. I think Mr. Innes has given a very full response on the process that they have followed and the appointment of experts to feed into the preparation of the document, who are bound by their professional bodies. So
it's just
I don't think I need to hear any more on this particular subject, to be honest with you.
Yes, we mentioned policy. You mentioned, we were dealing with policy as well in this inquiry, and so I thought that's also that's worth talking about. If policy is to be a part of this inquiry, then surely that should be an element of policy that needs to be considered.
Well, we're considering the proposed development in the context of existing national planning, renewable energy policy, and the local policies that apply through the strategic development plan and the local development plan. So we've had that discussion, and it was really about interpretation of that policy that's in place. So I think I've heard what you had to say. I've heard Mr. Innes's response, and I don't think I need to hear any more on how and who should prepare an EIAR. So I don't know if you have other questions that you might like to ask.
No.
Okay. Any further you'd like to add, Mr. Innes?
I think to say that in terms of considering of carbon balance, that we have a carbon balance calculator that takes into account peat and deforestation in carrying out that overall balance, and equally in terms of the assessment of the peat soils and peats, these are done extensively, and again the government have their own advisors on slide risk and other matters, so it is a topic to which they're very alive and are fully considered in the consideration of the overall carbon balance, and equally understanding the nature and character of peat, and that has to be considered in the context of its quality, and the extent to which, for example, existing monoculture forestry has already impacted on that peat resource. And there are opportunities that will be taken during the habitat management plan to actually counteract some of those and do some positive measures back. And it's recognised that the onshore wind industry in Scotland has led Scotland in terms of understanding how to recover peatlands and to effectively restore them to high quality habitat. And quite frankly, if it hadn't been for the onshore wind industry, we would not know how to do it. And we now have techniques which we can deploy, which have been studied over many years, which have led this country in terms of understanding how to manage and effectively restore peatland habitats that have been damaged. So I'm just responding to that criticism because I don't think it's as simple as the way it's expressed. And equally, as I say, we have extensive experience in Scotland in restoring peatland habitats. And that's why we have habitat management plans, because we know what works and it can be very effective, and it recreates that quality habitat with its much greater value, both in biodiversity terms and also ultimately becoming and returning to its ability to capture carbon. So I don't think it's fair to criticise the onshore wind industry in that respect, but it's been an absolute catalyst for developing the expertise and the technologies to actually do a meaningful response in terms of peatland restoration. I don't have anything else that I really wish to respond to. Thank you, sir.
Okay, thank you. Mr. Innes, I've just got a few tidying up things to ask you. There's an outstanding objection from Scotways. They did at the outset of this exercise say they wish to be part of the inquiry process, but they subsequently dropped out. I just wonder what your intentions are with regard to addressing the points that Scotways raised, whether that's going to be in a separate submission, or indeed you may choose, you may tell me that you'll perhaps pick up on all the points that have been raised by outstanding objectors in your closing submission. It would just be good to know how you intend to deal with those.
Address it in my closing submission, but I hope that when you went to site, that you might have been shown the right of way.
I was indeed, yes.
Yes, and I think it almost speaks for itself from having been shown that. I mean, I don't intend to make a great play, but I think it's something which you can probably best appreciate on site, and hopefully that will have seen the right of way,
yeah,
markers, etc. Yes.
Okay, thank you. Okay. Okay, Mr. Finlay, I don't know if you wanted to respond to anything that you've heard throughout the course of the morning.
No, I can save any comments for closing submissions.
Okay, right, thank you very much. Okay. Now, I just wonder how best to proceed. It's just after 11:30. We've got a hearing session on draft conditions, whether it be most appropriate to perhaps conclude there and start first thing this afternoon, or whether we take a break and start again. I know that we've got quite a bit to get through on the conditions. So any preference, Mr. Finlay, Mr. Innes?
My preference would be to at least make a start now, and it appears to me that the positions of both parties are reasonably well set out in the schedule, but there is a bit to get through, so okay. I think it would be appropriate to start after a short break.
Okay, is that the same for you, Mr. Innes?
Yes, I think that would make utter sense that we should commence and okay. But before we close this session, again, I would on behalf of the applicant thank those that have taken the trouble to complete the application. We may not have agreed on all topics, but we fully support the view that everyone should participate and have that proper engagement and dialogue. And if I may say, all the presentations this morning were very clear on the issues that were raised. And I know clearly in order to make those presentations, people have taken time and trouble to make them. And there are points which are relevant. And obviously we will respond to it and deal with those matters in submission. But I just wanted to note that we do recognise the time and the clarity of those submissions that have been made this morning.
Okay, thank you very much. Well, if I could thank Mr. Denny for his assistance to the inquiry. I forgot to do so the other day, so thank you, Mr. Denny. So what we'll do now then is we'll perhaps take a 10-minute break. So we'll reconvene at 11:45, and we'll open the hearing session on draft conditions. So, and thank you, Mr. Strawn, for your participation, and you, Mr. McGowan. And I don't know if you want to stay and observe the discussion on draft conditions. You're more than welcome to do so. So, and thank you too, Mr. Clapham. Okay, let's take a 10-minute break. Okay, can I just check that everybody who intends to be taking part in this hearing session has joined the call? Okay. Okay, let's make a start. Well, I don't see any new faces on the screen here, so I'll dispense with the formal introduction, but welcome to those that have joined the hearing session. I would remind everyone that the hearing is being broadcast live to the DEPA website, and that a video recording of the meeting will be retained on the website until ministers are taking a decision on this matter. I trust you've all received the agenda for the hearing session. As before, I will lead the discussion based on the points listed on the agenda, and I propose that we simply run through the schedule of conditions in numerical order. Can I just check that we're all using the same schedule dated the 10th of September 2001? Yeah, super, thank you. As with the earlier hearing session, there'll be no cross-examination of those taking part, but if you need to ask questions, then please do so through me, particularly if you don't understand something that's being said. And I will be taking a note of the discussion, so please bear with me when you're giving your answers. Can I just confirm who will be taking part in the session? So for Fetteresso WIN Limited, Mr. Innes, who will be taking part?
Okay, but thanks. It will be myself, Ewan Hutchison, as introduced yesterday, and Mr. Innes is still here.
So I didn't catch that. Is Mr. Innes intending to take part? If
Yes,
he be?
yes.
He is, super. Okay, thank you. Mr. Finlay?
So both myself and Mr. Hewitt.
Mr. Hewitt. Yes, I thought it was Mr. Hewitt, but the way your camera is set up, he's in the distance. So, okay, thank you for confirming that. Okay, well, I see that there's probably agreement on nearly half of the conditions, draft conditions that are proposed. And I just wanted to touch upon one or two things in the early set of conditions that would be attached to a Section 36 consent. Perhaps Mr. Hutchison, I see in condition 2, the condition as drafted suggests 6 years rather than 3, which is noted in the model condition. And I just wonder what the justification is for that longer period to commence development.
I think principally the connection date, sir.
Sorry, I didn't catch that. It's the
grid connection date.
Right.
Yeah, which is currently at 2026.
Okay, thank you. And again, just a minor point, on condition 4, there's this serious incident reporting. In the past, when I've dealt with these kind of conditions, reference is also made to the planning authority. Just thinking those that might see an incident would perhaps tend to respond to the planning authority before they would Scottish ministers. So would you consider that would be appropriate to add into the wording of that condition? And I'll ask Mr. Finlay the same question in a moment.
I think so, sir. I think it's probably a legal matter as much as any where that condition then sits. Is it a planning condition or is it a Section 36 condition?
Okay. Mr. Finlay?
So I don't think we have either of us anything to add to what Mr. Hutchison has said. Okay,
thank you. Condition 6 deals with aviation lighting, and Mr. Innes yesterday made reference to a further letter from the CAA about the number of turbines which would be lit. I haven't seen that correspondence yet, but would this be the appropriate point at which to make reference to the lights, which are turbines which are to be lit?
Yes, sir. The turbines which are proposed in the agreement between the applicant and the CAA are turbines 7 and 10.
Okay.
But I think that the condition as worded facilitates that without any specific changes.
Okay.
Just to say, so I think one of the points would be that it's a sort of comprehensive scheme. What we've put in is the, to push the CAA as to the extent to which they are required. We've then got all the specifications to be approved, and it's still need the scheme to formally submit and approved through a process, I think.
Okay.
Normally what would happen is we would do this work and then it would get presented with the full details, and having the background of having had the engagement with CAA, the discharging authority then consults the CAA and said yes. So I think it still needs that process, as it were, as opposed to just being us sending a letter to a folk we've engaged and we're down to 2 lines, because we've got all the specifications to approve as well.
Okay, so just to be clear, with the response from the CAA that I'll see in due course, is there any necessity to amend the wording of that condition?
No, I don't believe there is, sir.
Okay.
No.
Thank you.
I think, as Mr. Innes says, the condition provides the process by which that can be agreed.
Okay. Anything to add, Mr. Finlay? Okay, thank you. Okay, now turning to the draft conditions that will be attached to the deemed planning permission. I see there's agreement on condition 7, but there isn't on condition 8. So this one deals with the redundant turbines. Mr. Finlay, perhaps I could ask you to run through the council's suggested rewording of that condition, please.
I'll ask Mr. Hewitt to deal with that.
Okay, thank you.
Mr. Hewitt will be dealing with most of our responses.
Okay.
Thank you, sir. Yes, the redundant turbine condition is set out by the council. Really just seeks to add a little bit more structure. I would open by making one point. After reviewing some other Section 36 consents, I think on reflection, the reference to 6 months within the first part of our wording, we would be quite content for that to be increased to 12 months in line with some other decisions which have been taken. But we do feel that our wording is perhaps a little bit more robust in terms of setting out expectations, in terms of timescales to submit details of works to be carried out and a timescale for that to be implemented. And I would also highlight that our condition does seek to provide a degree of flexibility with the phrasing of unless otherwise agreed in writing with the planning authority, to reflect that circumstances can be difficult on the ground and there might be exceptional circumstances where the exact timing of the condition can't be met. But I think it does a reasonable job of setting out our expectations, and it's in line with a couple of recent decisions. The North Lothian one was 12 months with 3 months to submit a scheme and 6 months to implement. Blairgar was 12 months of non-operation, 28 days to submit a scheme and 6 months to implement. So we've tried to strike a balance there, but it's really just about trying to be precise and to set out our expectations right at the start of the process more than anything else. Thank you.
Okay, thank you.
So I would
the reference
to Blairgar is a wind farm decision that was made, I think, published yesterday, which we only became aware of this morning. It's just the most recent decision with conditions attached, which you may find of interest. I think hopefully a copy was sent to Mr. Innes this morning. We're not intending to make a particular detailed submissions with regard to it, but just reference it as appropriate along with other decisions. The North Lowther one is already in the core document list. I can't remember the decision number at the moment, but it's...
Yeah.
Thank you.
All right, thank you. Mr. Hutchinson.
Yes, I think happy with what's been suggested by the council this morning. We had requested 12 months previously. We discussed that at length with the council. It's been a recent experience that 12 months is has become both the norm, but I think from the more importantly from an operational point of view is considerably more practical. So happy with the move to 12 months, and happy to accommodate the council's other minor suggestions or issues with the time period, not the detail.
Okay, moving on to condition 9. Now this isn't agreed either. It's about the financial guarantee. Mr. Hewitt, do you want to run us through the council's position on this condition, and then I'll ask Mr. Hutchinson for his thoughts.
Yes, sir. I'll try not to retread ground because I think the council's position is quite clear within our comments. This is the approach that we have generally taken as a council to restoration and financial guarantee for numerous kinds of projects, that being wind turbines, minerals, wind farms. And I suppose the point of contention with this, to my mind, has largely been over the wording that requires a stop to operation in the event that the financial guarantee fails for whatever reason. In terms of where the council has got this condition from, it's a variation of a condition, model condition suggested by the Heads of Planning Scotland Energy and Resources Subcommittee in their position statement on the operation of financial mechanisms to secure decommissioning, restoration and aftercare of development sites, which dates from October 2018. And really from the point of view of the council, we feel that the stop to operation until, in the event that a financial guarantee becomes invalid, and the stop on operation until such a time as a new one is in place, is really quite key from the point of view of protecting the council from exposure. Because if we allow development such as this, or any development that requires a significant degree of restoration to operate without appropriate safeguards in place, should the unthinkable happen, and for whatever reason the site need restoration and a party is not in a position to provide that, our concern would be that as a council we would be exposed to a risk of having to carry out that work and the associated costs. And certainly I don't think the stop on operation should be particularly contentious, given where or the background of this condition and the background of why this is come about. I know that certainly when the HOPS committee were formulating this condition, they had regard to a lot of the bad experiences in relation to minerals in South Ayrshire, I believe it was. And really, there's a lot of principles that would still be applicable to wind energy developments because they do introduce a significant degree of infrastructure that does require potentially a high amount of restoration at the end of its operational lifespan. But I think that would be about as much as we would say, and would be quite content to rely on what's within the condition list, our comments within that.
Okay, thank you. Mr. Innes, I see that the camera has switched to you. I presume you're intending to respond to this one. I see from your comments that you see there's a question of the legality of the wording that's been suggested by the council.
Well, what I'm concerned about is that electricity generation is deemed as essential infrastructure. And simply put, if this was replicated across the wind farm sector, then there is the potential for havoc to be created in the generation sector. And what the council seems to suggest is this is a reasonably easy thing to rectify. They have to approve who we get the financial bond is from with in terms acceptable to planning authority. If one of those rock solid parties who's guaranteed the restoration obligations has gone bust, it is likely that we'll be in circumstances that are not dissimilar to those that we find ourselves in 2008-9. Now, anybody who worked through that environment, we looked at institutions that we thought were rock solid, and they disintegrated overnight. The second thing that happened overnight is no institution was able to expand their balance sheets in order to give further financial guarantees. So in those circumstances, not only would we end up with a financial crisis, but through planning conditions, we would then transfer this into a potentially national energy crisis by wind farms having to be switched off across the country. And there are not that many providers of financial bonds to this sector. And equally, there also has to be financial guarantees to the offshore sector as well. I think this is disproportionate in relation to what is sought. And furthermore, there is a fundamental difference between a quarrying operation and the delivery of new, clean, green electricity required in terms of the electricity system. If I continue to operate my quarry, I actually continue to increase the need for restoration. Whereas in terms of a wind farm, it is fixed at the point at which the development is completed. So once the development is completed, we're not creating any additional requirements in terms of restoration. So there is this fundamental difference. And in my submission, if this were to be imposed, as I say, it may create very difficult circumstances. Second point is that contractually, in terms of CFD auctions and making electricity available and confirmed, I think this may well cause a significant problem. So in terms of those particular aspects, in my submission, there may be issues of illegality in relation to imposing a condition which interferes with the provision of essential infrastructure in those circumstances. I think it would be unreasonable and certainly not one which has got precedent in relation to Section 36 consents. And I note that the consent that's recently been referred to, granted yesterday, does not have those matters in it. And as I say, I think it's a matter of significant relevance to the Scottish ministers, because obviously they would have this overall arching consideration of the national interest and the role which energy production plays in that. And I think when that is viewed in that context, I don't think they will view that this is an appropriate response, that wind farms would have to shut down in those circumstances when they're providing that essential infrastructure required for the system.
Okay, thank you for that. Mr. Finlay, Mr. Hewitt, would you like to respond to that?
Yes, perhaps I shall take on the mantle for this one. First of all, there's no fundamental difference in the operation of the condition between this condition and condition 8, which requires removal of a turbine in certain circumstances. So that the basic underlying structure in our submission is perfectly legal, and I don't believe Mr. Innes suggested otherwise. second point is that is to respond to Mr. Innes's submissions on essential infrastructure. In one aspect or analysis of his submission, it's a timing issue. If a bond becomes invalid early on in a wind farm life, there must be scope for ensuring that that is replaced. And if it's consistently not replaced, then in our submission, the consequence that provided for by the condition is perfectly reasonable. Whilst I accept there's a difference of approach with quarrying, in our submission, the ultimate consequence of failure to provide a bond would be to leave the council with the liability for that which the guarantee seeks to cover. In our submission, it's not disproportionate, and were the sort of financial meltdown to arise that occurred in 2008, there is provision for the planning authority to provide agreement to continued operation, and that would happen in such circumstances. And lastly, as to the contractual issues may well causing problems on CFD matters, in our submission that this has been, there's no evidence of that, and as far as the council is concerned, the proposed condition and proposed HOPS conditions should be implemented. But it's a matter for ministers. I understand the gravity of the point that Mr. Innes raises, but in our submission, this condition, potentially with an increase in timing, is appropriate.
Anything you'd like to add, Mr. Innes, having heard Mr. Finlay?
I'm going to make a secondary point, is that if you look at government policy, it's trying to encourage the deployment of onshore wind. Onshore wind, as set out in the 2017 policy statement, has real challenges in being brought forward. And what this adds to is another risk. And it doesn't really matter if Mr. Finlay says it's okay, the council might be reasonable. But that is not what the future operation of a multi-million-pound infrastructure project should be reliant on. If an infrastructure fund is ultimately going to potentially fund the project, own the project, or whatever, who knows? If finance comes in and it sees a provision such as that, they'll have to evaluate that as a further risk. And that adds to the uncertainty about delivery. We're already having to provide a financial bond in terms satisfactory, and effectively what they are saying is give us a guarantee from a really reputable party regarding these restoration obligations. But actually, you've got to re-guarantee that and find somebody else to do it if there's a problem within 12 weeks. And the difficulty with that is it all sounds fine until you go and ask for project finance and people crawl over the risks registers involved in this. And that essentially means double bonding potentially, because they'll have to cover that risk off as well. I just flag that it's all very well talking about these conditions in isolation, but down the line, lots of other parties may have to review these conditions and consider their implications for commercial viability. As I say, being at the whim of a council as to whether you can operate after 12 weeks, as I say, we've lived through times when precisely the circumstances that exist occur, and shall we say, everything falls into a very difficult circumstance. And as I say, this is actually the council looking for a double guarantee. So can you guarantee it and can have a guarantee after that? We're obliged in terms of condition 1 to keep the guarantee in place. If we don't, we'll be in breach of condition 1. council essentially introducing is a mechanism for forcing that out with the standard enforcement measures called in a condition. And in my submission, that's quite telling, because at the end of the day, they've got an obligation and they've proposed it, and they're saying, if you don't comply with that condition, you know you can just stop. Now, there are provisions in the legislation in circumstances where effectively the council can issue a stop notice. But the issue is there's very significant consequences for councils doing so. So what this is effectively is the council subverting the legislation and introducing a stop notice effectively at their will if there's a breach of this condition. And that's my major concern, sir, because this is a planning condition. They've got the full panoply of enforcement. And if there's harm being caused, they can use that. Otherwise, use the panoply, reach a condition notice, etc., in terms of the process. So in my submission, effectively, it's an enforcement mechanism being introduced by the back door that's effectively a stop notice. And if they want to serve a stop notice, do so, but they then face the consequences for doing so. And that's all I wish to say on the matter, sir. And I don't think I really need to continue any further on that particular matter.
Okay, so Mr. Finlay,
Can I
got some further comments?
Yeah, can I briefly reply? I spoke too soon when I said that I didn't think the underlying legality was in dispute. Mr. Innes has just submitted that it subverts the process of stop notices. I reiterate our submission that it's no different from the provisions in Condition 8 and indeed many other conditions where reliance on stop notices or enforcement notices aren't required. It is a matter of risk, and in our submission, this is an appropriate way of dealing with the risk, and that it doesn't fall with the council. As I say, if it's a matter of the details of the proposed condition, that is a matter which the council is content to be flexible about, but in our submission, the principle is an important one.
Okay, thank you. I've made understand what each party is saying, and I'll certainly go away and reflect on what I've heard. So thank you for that. Right, condition 10 deals with the construction environment management plan, including construction method statement. And again, this condition, the wording of this condition hasn't been agreed. Perhaps I could ask Mr. Hewitt to set out why the council favours a different wording, and perhaps it would be appropriate here to address the separation of the preparation of the management plan and the method statement into a separate condition. So, Mr. Hewitt.
Thank you, sir. Yes, you've already hit the nail on the head there in that the primary difference between the applicant's wording and our wording is that as a council we would like to see the condition broken up, and it's primarily into a CEMP and a construction method statement. There are other aspects which are flagged as additional conditions which we'll touch on later on. However, from the council's point of view, this is born out of our experience of dealing with other similar large-scale projects. In particular, the Moray East and Moray West onshore elements come to mind, and to a lesser extent, the North East 400 kilovolt upgrade, which was 106 kilometres of pylons being upgraded across Aberdeenshire. And experience with these kinds of projects, which cover a vast area and vast tracts of land, has taught us that a single large document often becomes quite cumbersome and unwieldy from an administration point of view. So our preference is for these to be split up quite neatly in order to aid us in terms of file management and in terms of how we disseminate this information and share it with the appropriate consultees. So really, while I think content of the two conditions is largely similar, it does come down to, I suppose, how user-friendly these documents are. I do accept the applicant's point in their submission that from an operational point of view, it's easier to have a single document to refer to on site. So it is just a competing balance there, I guess, but perhaps multiple documents could be put into a single folder, but I do think from a submission point of view, when it comes to assessing the content of these, it's much easier for us to manage these kinds of documents as standalone. The second point that we have raised within this would be, regardless of which style of condition is chosen, we would be quite keen to encourage a schedule of mitigation to be attached as a part of this condition, and this should cover any and all mitigation contained with the EIA, with a reference to where it's also covered within the CEMP, and this would just aid in reference for any parties that are looking at these documents to see very clearly where the roles and responsibilities lie and how these mitigation measures are going to be implemented through these documents, if indeed they are carried through these documents. I'm completely aware not all of them would fall within the remit of a CEMP. And I would just say, on splitting up the document into CEMP and CMS, there is a bit of precedent with Paul's Hill Condition 13, which covers both the CEMP and CMS as separate documents, although notably under one condition, from my recollection. But I don't think I have anything else to add.
Okay, sorry, just run that past me again. Condition 13 of which decision, which development?
Paul's Hill.
Oh, Paul's Hill, sorry, yes. Okay. The camera's still on you, Mr. Innes. Would you like to respond to this? Mr. Hutchison, would you like to respond to what the council's had to say?
Certainly, and I think Mr. Hewitt has actually sort of covered the principal point in that our preference, and again it comes from practical experience, is to have as much as possible, and this is something that we'll maybe come back to in relation to other suggested policies, but to have as much as possible in a single document, whether it's called a SEMP or a CMS or both, but to have it in one place so that when it comes to the process of building out the wind farm, that the team on site have basically one point of reference. They're not having to go between different documents, which invariably will get split up and so on. So if it's all in one place, it makes it much easier. The intention of all of this is to avoid things from going wrong, to prevent pollution, and so on and so on. And I think that from our experience is easier to achieve if everyone is working to one set of rules and not several. And really, that is the difference. I noticed that Mr. Hewitt sort of has given rise to their experience over different projects, which I think are very different in their character and their nature. They're much more geographically extensive. We're dealing with one contained site. It's an existing site where these measures have already been implemented. So yeah, I think just from that practical sense, we'd prefer it to be in one document. If it just, I don't know if you want to deal with that point first. I have one other point to make on the proposed condition.
No, on you go, your second point?
So it was really just to pick up on a point that was raised this morning about private water supplies. The applicant would be more than happy to have an additional point added. We're looking at potentially point I of the original suggested condition in relation to drainage management, and that if reference at the end of that to private water supplies was included, that would be acceptable to ourselves. But happy to leave that with you, sir, as to how you want to best include that. But I think it's reasonable to do so.
Okay, thank you very much. And I take it the council would have no objections to that suggested change to add reference to the private water supplies.
Thank you, sir. I think on the private water supplies, we would consider a standalone condition maybe slightly more appropriate. However, if it were to be incorporated into the CMP, we would just draw your attention to the secret responses within core document 1.11.2, which provide a little bit of guidance as to what they would be looking for in terms of private water supply conditions. But ultimately, yes, the decision about whether or not it's a standalone condition or whether it's would obviously be down to yourself.
Okay, thank you. Right, I see there's agreement on conditions 11, 11A, 11B that deal with transport, traffic management of normal loads and any signing or temporary traffic measures. So that's good. Condition 12 deals with micrositing of turbines, and I see that there isn't agreement on that one. Again, Mr. Hewitt, perhaps I could ask you to set out why the council would prefer an alternative wording to the condition.
Read that, and I think I sort of alluded to that in the opening first day that we've continued to make progress with the council. That was a condition that we have now agreed.
Oh, I beg your pardon. Yes.
Pleased to say, after lengthy discussions.
But I haven't seen that reworded condition yet. I take
it's the council's one. We agreed the council's provision.
Okay, right.
Just a couple of points as we go through. Going back to the applicant is happy, as we've said in our comments, to include a schedule of mitigation. Sorry, I should have mentioned that at the time. On condition 11, although there's no disagreement between the parties, I think, again, just picking up on some points raised this morning, I would draw your attention to, it's condition 11, but part 1B and part 1E. Part 1B is measures to ensure that specified routes are adhered to, including monitoring procedures. And part E is identification of a nominated person to whom any road safety issues can be referred. And I think that at least partly deals with the points raised this morning by some local residents.
Yes, thank you for reminding me. I had made a note to ask that question, but kind of overlooked it just at that moment. So thank you for drawing that to my attention.
Yeah, sorry, I don't know if it's appropriate for me to speak, but can we make it specific rather than, as opposed to you must use access routes, make it clear that you can't use these routes?
Well, the wording of the condition is that the routes would be specified. So
yeah, it's the same thing, but yeah, I'm just thinking of the people that access them. Make it as clear as possible.
Well, I presume that they
and the other aspect that the farmer, the track owner, asked for, if you're referring to Chapelton, was that it was clearly signposted. There was no access to the face.
Well, a condition that there would be a condition that would deal with the signing and any temporary traffic measures that would be required, if this development was to proceed and to be constructed.
Okay, but he asked specifically that it's signposted no access on his track.
Okay. Well, I'm not sure what the rights of access are over the track.
Prescription is only for forestry, tree activities. He's already been through that. Anyway, you need to check that on the council. But we want to make it absolutely clear there is no worker access, no materials, deliveries, secretary.
Okay. Well, clearly it's easier to define a route than to define lots of routes that are not, to be used.
Understand that, but that didn't work the last time. So another solution is required.
Okay. Any comment, Mr. Hutchison?
No, I think these are points of detail, sir, which would have to be worked through with the council in agreeing the traffic management plan, and I think we'll leave it to that process.
Okay. I'd say that often, in terms of the signage, it's making sure the signage is early enough to direct traffic. So the council's transportation department may say the right place to have the directions isn't actually a way up close to the site. You need to essentially direct the construction traffic as well, and that's where the whole signage strategy would be dealt with. So the problem of somebody arriving on a particularly sat navs is that they have to be directed before they get to where they get to. So that's the key, is working out where that should be, as opposed to saying, I've put a sign up, halfway up a private access. Well, if there's a lorry already come up there, you've already had the problem. So
sorry, you misunderstood me.
The key proper management, and I'm afraid to say that needs to be planned with proper transport engineers, with proper signage. So, and that's what this provides for. That's what the condition provides for, is that for essentially the roads and highways authority to have the proper management of the process and appropriate signage. Now, appropriate signage is also to have regard to trying to ensure compliance with the routes that have been selected, and that's the way in which it's been phrased. So I think the key point is measures to ensure that specified routes are adhered to, including monitoring procedures and details of signage and lining arrangements put in place. Well, all that directs that you've got to consider where they're likely to come from, where the vehicles are going to, and to ensure you have directions in place and signage for those, as opposed to just saying at one location where they've already advanced too far that they've arrived at a potential access. So, as I say, the proper signage is a matter that needs proper design, and that's why we're going to the traffic management plan.
Okay, but I understand that.
Reports, though, no doubt you can, if you are writing a report, no doubt you will be reflecting on the matters that have been raised by Mr. Burgoyne, and no doubt that can be reflected in any report that you write. You've been and seen the particular issue, and no doubt your views could be reflected in a report, and no doubt that becomes part of the overall decision making in relation to any consent if it were to be issued, and that would be a set of context for further matters in the traffic management plan.
I understand all of that, but it didn't work last time. So I'll leave you on that point.
Okay, thank you, Mr. Burgoyne.
Thank you.
Perhaps we could just add something on. Mr. Hewitt would like to respond.
Yes, Mr. Hewitt.
Thank you, sir. I think the use of signage is definitely going to be key here. So I do think the existing condition probably does cover that, so we'd be quite content with that. The only additional point I would perhaps suggest adding, and this is reflective of the discussions that have went on this morning, would be it may be appropriate to suggest a single point of contact is identified within the traffic management plan, so that should any issues arise, the local community would know who to contact within the site. And yes, while that might not address the event of a vehicle going up a particular route when it shouldn't have, but it may be a way of ensuring it doesn't happen again or happen as often. We've used that quite successfully in other projects, but that
Okay.
as much as I would say.
Okay, thank you for that.
Can I respond just on that, just for a clarification as much as anything else? Is that not already covered in E? Point.
My apologies, it does seem to be. I'd overlooked that.
Yes, I have a note of that. Okay. Thank you, Mr. Hutchinson. Okay, moving on to condition, draft condition 13, the design and operation of the wind turbines. Again, there's disagreement here, particularly in relation to clause 5 and clause, was that an addition of clause 5 that's suggested by the council? Perhaps I could ask Mr. Hewitt to just set out the reason for clause 5 in the suggested draft condition by the council, and I'll ask Mr. Hutchinson just to set out the council, the applicant's concern with that. So, Mr. Hewitt.
Thank you, sir. Yes, clause 5 appears to be the only significant difference between us on this. To the council's mind, this is a fairly standard caveat to add to one of these conditions, and indeed it can be seen within Paul's Hill decision and the North Lothian one. And really the intent behind this aspect of the condition would be to ensure that the turbines as described in the EIA in terms of visual appearance, because obviously colour is an important consideration to how these sit within the landscape, really to make sure that that is maintained through the operational lifespan. And I think that concerns have been raised perhaps that a degree of rust is inevitable on these, and certainly when you go on site you could see or travelling about the countryside you can see examples of turbines where there is a degree of it, but this is really just to protect against the extremes and to make sure that the landscape and visual impact that's been assessed as part of the EIA is reflective of the impact the turbines have over the lifetime on site. And yes, I think that's all we would say on that.
Okay, thank you. Mr. Hutchinson, your response?
Again, Mr. Hewitt has covered the principal points of disagreement. Our main concern is with 5.5, starting with the wording free from external rust, staining or discoloration, and down to the turbine. I think the free from is really the part which causes concern, because again, although we can sat here, we can hear the sort of the commitment to be reasonable in its implementation. I don't think that can be relied upon in perpetuity. So my suggestion would be that middle part of that sentence, from free down to turbine, is removed, and that what's retained is maintained in the approved colour until such time as the wind farm is decommissioned. And I think that adequately covers all sides. It's not in the operator's interests not to maintain the turbines in good order. They are, in this case, I think 35 years. You know, they're going to have to be repaired. Nobody's going to let them rust or deteriorate to an extent that they're kind of going to suffer and fall down or anything like that. So It's how to kind of capture that reasonableness. And I think there's enough within that, the main part of the condition, without having to impose a free from sort of markings. It just seems unreasonable.
Okay. Okay. Well, I've heard what both parties have to say on that, and I'll give that some proper consideration. So, okay, thank you. Okay, I see there's agreement on the design of the substation. That's condition 14. And also agreement on the draft fish monitoring and management plan, and that's also agreed. We've perhaps already had a discussion around condition 16. This is the environmental clerk of works, and that's not agreed. So perhaps I could ask again, Mr. Hewitt, if you just want to run us through the reasons for the council's suggested rewording of or an alternative wording for that condition, and then I'll come back to Mr. Hutchinson for his response. So over to you, Mr. Hewitt.
Thank you, sir. The council's approach to the environmental clerk of works condition really reflects experience that's been relayed to the council through involvement in various HOPS groups and subcommittees, where it's been expressed that on occasion, ecological clerk of works find it difficult to ensure that reporting takes place to the council in an appropriate timescale, owing to terms of employment, and really having a strong direction within the conditions to ensure that the council is notified of significant events on site or significant breaches of controls on site really just serves to provide a degree of backup, I would say, in allowing and enabling the ecological clerk of works, environmental clerk of works to carry out their role as envisaged, to make sure that appropriate monitoring is taking place and that they are appropriately empowered to make sure that breaches are reported. I would say, in saying this, we would caveat it with, we don't need to know absolutely everything that happens on site. It would be in terms of working out what the significant events are, and obviously a lot of that would be down to the judgment of the ecological clerk of works as a professional. So we don't want this to place too onerous an obligation on any party, but I think it's important to make sure that the role can be fulfilled as honestly as possible. And again, it's based on experience that's been relayed to us through involvement in HOPS. But I would leave it there.
Okay, thank you. Okay, Mr. Hutchinson.
Yeah, again, I come back to the points we made on the purpose of these conditions and the way that they're implemented is to avoid incidents and as far as possible, and where incidents do happen, that they're addressed as quickly and as sort of efficiently as possible, and that having to almost run to the council every time that there is a potential incident doesn't necessarily achieve that objective. So I think what we'd set out initially was what we felt was a practical way of dealing with it. And I noticed that the council has drawn our attention to the Clerk of Works condition 8 on the Blairgower decision. And I think our main sort of issue at the moment in terms of the proposed condition by the council is their point 3 and the final sentence of their point 3, where it requires the ECOW to notify the planning authority at the same time as the company's nominated construction project manager. Now, in a practical sense, if an ECOW is on site and comes across an incident, the first thing they need to and should do is go to the company's construction project manager and ensure that that incident is addressed as quickly as possible to avoid it escalating or becoming any worse than maybe the case. Once that is dealt with, then I would think it's reasonable to go and report that to the council, either in the monthly report, which was suggested, or perhaps in the way that the Blairgower point D is written, at the earliest practical opportunity. But I really see no practical benefit in the ECOW having to report to the planning authority at the same time as trying to deal with it. You know, unfortunately these days, anyone trying to get hold of officers within councils, it's not always possible to get a response there and then, and I wouldn't want that you know, lack of availability perhaps to be the sort of hindrance to sort of dealing with these issues on site at the appropriate time and in the appropriate way. So I think we're reaching for the same thing. I think we've just got different ways of achieving.
Okay, now.
So perhaps we can come back and just say that, as I understand it from Mr. Hewitt, although you don't have it yet, we'd be happy with the wording in the Blairgower condition, which would appear to be what Mr. Hudson might be happy with.
Okay, thank you very much.
I think the only thing that I would say, so
yes, sir.
So yeah, the Gower one is any instance of non-compliance. Now, I think that might be overstating it as well. I mean, that might be too much. I mean, that's why there's monthly reporting. If there's minor incidents, they will be picked up in those reports. But every single incident over a 18-month construction program, you know, I think that may well be more burdensome than is helpful. The fundamental point is we want the ECOW on site dealing with the construction, as opposed to spending the whole time in correspondence. And that their primary role is the forward planning of the construction process with the project team. And you know, whilst we sit here looking at it post the event and post incidents, that's the primary role where the ECOW influences the overall process, is working with the construction team of, we're going into this area, these are the sensitivities, these are what we need to apply, this is what I'll be looking for, this is what we're expecting. It is, that is, you know, it's not the milk monitor. The primary role of the ECOW is to get out there and help make sure positively, and it's not even about compliance. The real issue about the ECOW is actually driving the environmental standards of the project beyond that to saying, how can we best implement this project within the framework of the consent? And that drives also micrositing and the role that the ECOW plays there. So they're actually trying to make sure that the best environmental outcomes are achieved. And it actually goes further than compliance. It's actually going better than that. It's trying to really drive forward how to take within the boundaries of the project the best outcome for the environment. And that is done by the ECOW actually being on site with the construction teams, forward planning the works, looking at the sensitivities and making sure that those key issues are being addressed in advance of the process. There will always be incidents, but if there is a major or significant incident, of course, there should be notification if there's a material incident. But I think if you make it every incident, the ECOW is going to spend more time forward and not really doing that task, which is this oversight, which is best achieved on site with the construction process. I mean that's the way it works. And I just often it's misunderstood. The whole eco thing is misunderstood to being somebody that is a milk monitor and monitoring compliance. It is far more positive than that, and certainly the ecos that are involved are looking to make sure that it's the forward planning and making sure that things are done properly and thought through from that key environmental perspective, particularly in relation to ecology and water quality that we're seeking to manage.
Okay. Okay. Any further comment from the council on that,
Well,
Mr. Finlay?
Yes, so I think Mr. Innes is pushing at an open door as to the role of ECI. That's not in dispute, but enforcement is part of it, and I'll ask Mr. Hewitt just to comment very briefly on that.
Yes, thank you. As Mr. Finlay said, I don't think there's a lot of dispute in terms of roles and responsibilities. I think perhaps there's maybe a halfway house between our condition and the Blargar one, where as an authority we do not need to hear of every incident as it happens. Our condition sought to capture the most significant ones, and the significance being down to the judgment, professional judgment of the ECOI. So perhaps rewording to that effect would be appropriate and would capture our concerns and reflect the rules.
Okay, thank you. Okay, I see there's agreement on draft condition 17. That's the environment clock works for decommissioning. But moving on to draft condition 18, I see there is some disagreement on forestry and compensatory planting. Again, I think I understand the council's position. So I'll perhaps turn to Mr. Hutchison first to take us through why you didn't agree with the council's suggested drafting of this condition.
Yes, I think just to sort of say at the outset, there's no issue with the provision of compensatory planting as such. We're committed to the replanting of the 26.13 hectares as identified in the EIAR. It's principally the sort of this imposition of a sequential test, if you like, to the provision of that woodland. The replacement of woodland is a Scottish government policy. It doesn't specify, as far as I'm aware, any sort of regional requirement. The applicant, in this case, has secured land to deliver this, albeit out with the Aberdeenshire area, and I don't see that imposing this condition, helps the purpose of the condition to be realised.
Okay, thank you. A comment from the council.
Yes, sir. I'm quite glad that there is no disagreement with the principle of compensatory planting. We all acknowledge that it's something that's very important when it comes to developments of this nature, and indeed many other developments. The council's intention with the addition of this sequential approach is to provide clarity into how the council would likely assess any submission of a woodland replanting scheme, and it reflects our priorities as a council to maintain woodland cover within Aberdeenshire, and certainly to try and address the environmental impacts of the development as close to the development as possible. And it's fairly specific in terms of our preference within Aberdeenshire. Yes, this isn't written down in policy, but generally we do follow a preference for on-site adjacent to the site within the same committee area elsewhere within Aberdeenshire. And then crucially, elsewhere as may be agreed, if it can be demonstrated that there is no viable location within Aberdeenshire, or no achievable location within Aberdeenshire is perhaps a better term, we would be quite happy to consider planting out with Aberdeenshire. But it does tie in actually with aspects of wider policy of the Aberdeenshire Local Development Plan in broad terms. Our Protecting Resources policy seeks to ensure that impacts associated with woodland loss in terms of ecological and landscape impacts are addressed as close to the site as possible. And perhaps actually our natural heritage policy, E1, would come into play insofar as ensuring that biodiversity is maintained. We do try to go for biodiversity enhancement as far as possible, and compulsory planting does undeniably have a role to play within that. But that's perhaps getting a little bit off track. I think that from our point of view, this is just about providing clarity as to how we will likely assess the scheme when it is submitted to us.
Okay, but just to be clear, there's the sequential approach you describe. It's just the practice of the council. There's no kind of formal policy position of the council that's how you'd wish to proceed.
So far as I'm aware, sir, yes.
Okay, Mr. Hutchison, any further comment?
To that, no, I think that clears it up.
Okay, thank you. Condition 19 deals with noise, and this hasn't been agreed, and the council has provided me with a separate submission on noise. Just let me get that down. So perhaps I could start with you, Mr. Hewitt, on the issue of noise. Why you prefer the draft condition as you've set out in this separate submission, as opposed to the one that has been promoted by the applicant?
Yes, sir, thank you. The condition that we've provided is the one that we tend to utilise within Aberdeenshire, and it is based on primarily on the experience of our environmental health officers, and reflects the nature and way in which they prefer to receive any information in the event of a complaint in relation to noise. No, I'm not going to try and masquerade as an environmental health officer today, and be very unwise to try and do so. But I have spoken to our environmental health officer while we were preparing these conditions, and provided her with the suggested condition from the applicant. To read from her notes on it, she appears to suggest that the condition as proposed by the applicant derives from the Institute of Acoustics Good Practice Annex B, albeit with full ETSU R97 noise limits applying, as opposed to a table of noise limits for each property. Now, in practice for us, what this would, we would view this as a council as being less precise than the condition that we have suggested. You will note that our condition actually does include a table with noise limits to be attached to each property, and that's perhaps quite relevant whenever we think of some of the discussions that went on earlier today. The benefit, so far as I understand it from the discussions with our environmental health officer, is that the use of this table makes it easier to take into account cumulative effects of wind development than the condition as suggested. And really, it's about trying to provide more precision in condition in terms of what we deem to be acceptable noise limits at specific locations, and providing clarity as to the process and procedure that we would expect to be followed in the event of a complaint or a suspected breach. The council has had some experience of dealing with such complaints and using alternative conditions, and these have not up in the favour. We've been left in positions where we've been unable to enforce noise conditions, and really we would be much more comfortable using the condition that our environmental health service are familiar with and the one that they promote. And I would just say, in terms of the experience that this is based on, I believe that since 2003, Aberdeenshire Council has had around 803 wind turbine applications submitted. That's taken from information available on our website. So whilst I'm not suggesting the condition has been used back as far as that date, there is obviously a substantial basis of knowledge that has went into informing this condition. But I would say that's probably all I can say on this condition.
Okay. Just one further question. The guidance notes that's attached to the draft condition, again, have they just been developed by the council, or are they taken from elsewhere?
Unfortunately, I don't have an answer to that. I know that they form part of our model condition, which came about through discussions with our environmental health service and planning officers. But I'm afraid I would be unable to speak as to where they've come from initially.
Okay, thank you for that. Mr. Innes.
So, I do have some prior experience with Aberdeenshire Council noise conditions, and I can tell you that over the period from 2003 onwards, they have not been consistent in the way in which they've conditioned onto wind turbines. And at one stage, I'm pretty sure I know the Aberdeenshire condition that was drafted very well. It's diverted from ETSU. They chose to produce their own condition, and for a while did not apply the OA good practice guide condition. And I'm pretty sure the problems of enforcement arise from the very particular wording that Aberdeenshire Council used, which I've certainly seen and advised upon the problems of practically implementing from an enforcement perspective. The IOA good practice style has stood the test of time and has been effective in controlling noise and is consistently applied. The fundamental issue with the council's approach is it's flawed. The issue is this is an extension to another Section 36 scheme, both which exist and both which produce noise. And unless a cumulative condition is imposed, it will be almost impossible to enforce because effectively there is already the existing noise being produced by the existing turbines. And in all the circumstances where I've been involved in dealing with Section 36 extensions, the condition has incorporated within it a combination effect, i.e. what cumulatively can the extension deliver operating alongside the existing two. And so that is exactly what the applicants have done. They've set a base limit of 35 for the scheme operating alone, but equally it must also meet the cumulative limit set of operating in conjunction with the other two phases of Mid-Hill. That ensures that effectively the responsibility for meeting that cumulative limit sits with, quite properly, Fetteresso. So if it is built and operated, it has to ensure that it operates in a manner that ensures that the Mid-Hill 1, 2 and its operation do not exceed the limit. And that's the correct, it has to be right that there is that cumulative limit set that effectively covers that circumstance. And as I say, the problem with the Aberdeenshire Council limit, and it is consistent. The one thing they've always tried to do is if you put an assessment of the likely output from your turbine in an assessment, they say that's the limit. And the setting of cumulative limits has slightly moved on from not just being entirely set by what prior limits have been set, but it also then potentially restricts turbine flexibility and meeting overall limits. So my submission, when looked at properly, the applicant's condition actually provides a more comprehensive control regime, dealing both in the circumstance where Fetteresso operated alone, and I note that in relation to the recent decision that's just been handed to us this morning, Black Gower from Argyll and Bute issued yesterday, or made available publicly yesterday, that the 35 dB approach, as set out in Fetteresso, was used exactly in that circumstance. And therefore, the combination of that approach with the cumulative provides the most effective regime. The other difference between the two conditions is the provision of the amplitude modulation in condition 6 of the council's provision. The applicant does not agree to the incorporation of that and does not believe that the amplitude modulation add-on should be added on. The amplitude modulation condition as proposed continues to be a matter of considerable debate, both amongst acousticians and certainly by decision makers. And in my submission, the prevalent practice at the current time in Scotland is not to add that amplitude modulation provision, because it's not been agreed as the potentially the right response to the particular circumstances that can occur with amplitude modulation of excess amplitude modulation. And in my submission, until that position is ultimately reached and there is a consensus that it should not be applied. And amplitude modulation is a condition that occurs, but it is exceptionally rare. And Aberdeenshire Council is one of the council areas in which they have experience of enforcement in relation to amplitude modulation. And they will know that the circumstance that has primarily occurred is the type of turbines that they have recommended go into the lowland agricultural highlands. It's been 12 turbines in the 1875, and no doubt the council will be fully aware of the cases that those relate to. But those are the circumstances in which there have been issues with turbines with amplitude modulation. And in respect to this site, as we've heard, local residents barely hear the particular turbines that already exist at Midfield, and that is, as I say, we're predicted to be very similar. So in my submission, again, we have actual operational experience in relation to turbines immediately adjacent. My submission against that background, the applicant's position should be preferred.
Thank you. Mr. Hewitt or Mr. Finlay, do you want to come back on what Mr. Innes has to say?
Yes, I'll leave it to Mr. Hewitt to respond to Mr. Innes's environmental health evidence.
Thank you, sir. Just as a first point, we've located the source of the guidance notes, and they appear to derive from an Institute of Acoustics document, a good practice guide to the application of ETSU R97 for the assessment and rating of wind turbine noise. They form part of the example condition in Appendix B of that document. Our guidance notes are, our guidance note is lifted from that, so hopefully that clears up that point. There is a lot that Mr. Innes has said that, quite frankly, I'm not going to attempt to comment on, because as I've already stated, I'm not an environmental health officer. I would, however, highlight that the experience of the council to date when not using the condition that we have proposed has been negative. We had a case where we sought to take enforcement action, and it was a wind turbine at Tulmods, and this did end up being taken through the courts. The view that we were given was that the condition was so poorly worded that it was literally unenforceable. So from practical experience, practical recent experience of the council, we would be incredibly hesitant to accept wording other than the condition to which we are familiar with, which our environmental health team and indeed our planning enforcement team are comfortable using for enforcement. But that would be all I would say, sir.
Okay, just to be clear, you're saying that the wording that is suggested by the applicant proved unenforceable, or are you saying it was a variation of that that was unenforceable? Sorry if I've misunderstood you.
My understanding was the wording in the Tulmods case, which deviated from our condition, and I'm afraid I'm unable to say just how similar it was to that provided by the applicant, but it does show we've had very good experience to date.
Okay, but what you're saying is that when you've used something other than the condition as drafted by you in here, you've encountered difficulties.
Yes.
Okay, Mr. Innes, anything further you'd like to add?
Exactly. I've actually read the Tulmods condition. It's an Aberdeenshire Council condition. Aberdeenshire Council went out on their own, produced their own noise condition. Everyone said it wasn't a good one, but they prevailed with it. They went off on their own, they did it themselves, and they produced their own unique Aberdeenshire noise condition. That's the one that they're talking about that has been problematic. The version of document that I have produced is an IOA Good Practice Guide derived one from Hayes Mackenzie, probably one of the most respected noise consultants in the field. And they have advised that they consider this condition to be more appropriate than the council drafting, because the council drafting does not deal with the cumulative situation and equally does not all it does is tries to restrict to the predicted levels, which will be almost impossible to measure because of the existing operation of existing schemes. So the issue that I'm flagging to you, sir, is the council are making the same mistake again. So just to be clear, it wasn't the developer's condition that was found to be wanting. It was Aberdeenshire Council's draft condition that they produced that they felt was a unique and beneficial control of noise, and it turned out not to be, because it was poorly drafted and was found to have challenges already. The issue here is we're both using adaptations of the ETSI Good Practice Guide. I've incorporated cumulative limits, or proposed to incorporate cumulative limits in it, which is perfectly reasonable and supported by the Good Practice Guide. And our only other difference is the inclusion of the amplitude modulation guidance note, which, as I understand, has not been agreed by acousticians and arose from a report that was produced but has not been endorsed or adopted by decision makers, because there is still disputes as to whether it produces the right results or provides the right protection. And against that background, I don't think it is appropriate to impose that particular element of the guidance notes. So what we're really debating here is slight nuances of wording within two sets of conditions, which are both based on the IOA Good Practice Guide. But we're not debating two fundamentally differing approaches. And all I can say is that, having seen the previous Aberdeenshire attempt at drafting the unique position, I certainly agree that the endorsing the IOA Good Practice Guide produces a far better condition, one which has effectively stood the test of scrutiny and being considered. So I don't think we're as far apart as has been portrayed. I think we're both deriving the conditions from it, but as I say, the two bits of difference are the bits that I've particularly identified to you, being the amplitude modulation and the approach of having a cumulative limit as well as a single limit. And my single limit being 35, which is endorsed by the Scottish Ministers' Bangor edition, and the cumulative condition based on Chapter 13 of the Environmental Report sets out the background to this and the fact that there's already mid-hill conditions, and it reports on those and the levels which are set at sea levels as opposed to other levels, and that probably reflects the fact that there was Section 36. So therefore, that's already been set. Those condition limits have been set, and what we're saying is you can add us in, and we'll still keep within those that have already been set.
Okay, thank you.
Easier
Mr.
to-
Finlay, anything?
Yes, I'll ask Mr. Hewitt to respond briefly first, and then I may add something.
I would just like to clarify that in references to the toll mods condition, it was a condition that was not drafted by the council. It was not the council's condition that we are now suggesting. It was one that was imposed by the reporter in that case. The advice subsequent to all the difficulty and the challenges that we've had to it has been that we should have challenged it at the drafting stage, and that's exactly what we're trying to do here to make sure that we end up with what we consider to be a workable condition from the council's point of view. But I'll hand over to Mr. Findlay.
Yes, so in terms of amplitude modulation, there are clear differences, as Mr. Innes has referred to, but it is a condition that can arise, and Mr. Innes's proposal is to leave the residents unprotected, and in our submission the proposal for amplitude modulation is a reasonable one, and you should endorse it.
Okay, thank you for that. It's now 1:15. There's still a few conditions to work through. Can I suggest we take a break, or would people prefer to power through? I think I'd appreciate a break, to be honest with you. So would 45 minutes be sufficient to come back at 2 o'clock?
It's just to say that I totally appreciate it. It's been quite a long morning, and you get diminishing returns when you start to lose attention. And this is primarily to assist you, sir. And we've been going now for nearly 4 hours. So I fully endorse that we should have a break, and 3/4 of an hour would be entirely sufficient.
Okay, Mr. Finlay.
So in the face of unanimity between yourself and Mr. Innes, I'm not going to try to persuade you otherwise.
Okay, well, let's take a lunch break and return at 2 o'clock. Thank you very much. Okay, that's 2 o'clock. Mr. Hutchison, I can see you in shot, but I don't know if Mr. Innes is back in his seat. Is he there? Okay, fine. Let's make a start. If we could pick up on the draft conditions at condition 21. Again, there's disagreement here, and this is conditions about the management of habitats and species. And my observation here is that the council's been the applicant has drafted the condition to be quite specific to the issues that arise through this application, whilst the council seems intent on broadening the scope of the condition. And I wonder, Mr. Hewitt, if you could explain why the council feels it appropriate to add to this condition to address other measures as well.
Thank you, sir. Yes, so with this condition, again, it's similar to the approach that we have taken quite successfully in other large projects, that we tend to favour species protection plans as a mechanism when looking at management of species and habitats. And this is really to provide a level of comfort that there's a standalone document that can be pointed to, which sets out the rules and responsibilities of all involved in the process. Now, we completely accept that matters in relation to protected species are covered by legislation, and that I am more than certain that the applicants are aware of that. But from the council's point of view, we've taken this approach just to ensure, to our satisfaction, I guess, that this has been covered and that everyone is aware of their roles and responsibilities in relation to that. It also talks to the need for biodiversity enhancement and the strong presumption, or the strong focus we have on that in terms of policy, and it's to make sure that at the outset of the development, that in terms of management of species and habitats, that there's a long-term aim and goal insofar as where we're trying to get, particularly with habitat management, rather than, say, for example, putting in place a plan for a set period of time and reviewing it after a number of years. I think the long-term thinking is quite key in ensuring we're all pulling in the same direction. Just on the condition proposed by the applicant, the only thing that I would note within that, and it's something I've only actually noticed this morning, is that it says that a detailed habitat and species management plan shall be submitted to the planning authority. I think the wording there just needs a little bit of clarification. Is to be submitted to and agreed by the planning authority to make sure that it is acceptable in terms of how the site should be managed. But I don't have very much more to say on that.
Thank you, Mr. Hewitt. Mr. Hutchinson, any observations there?
Not specifically, sir. I think you sort of summed up our position at the start very well. If Mr. Hewitt is minded to go with our condition with the and agreed by the planning authority, quite happy with that. But yeah, the intention of this initially was to capture the sort of the positive enhancement and to some extent mitigation measures that were set out in the EIR, rather than to be a sort of, you know, fallback regulatory position, which I think is covered elsewhere. So,
okay, thank you. Now, there's also disagreement with the draft condition on programme of archaeological works. Now, the council has suggested a different wording, and the applicant has indicated that the wording as proposed by the council could have unforeseen circumstances. And I wonder, Mr. Hutchison, if you wanted to address address those unforeseen circumstances and the wording that's been proposed by the council?
Certainly, I think the additional wording suggested by the council kicks off a chain of events over which nobody seems to have any control, and yet we're supposed to down tools until that process has run its course. I really don't see what it adds or how it is necessary to the achievement of the ends, and it's not acceptable in its proposed form. I think, whilst you'd expect there to be excavation analysis, to have to wait for the publication, dissemination of the results and archive deposition of those results, I think it's just going too far.
Okay, thank you. Mr. Hewitt.
Sure. Thank you, sir. Yes, I have discussed this particular condition with my colleagues in Aberdeenshire Council's Archaeology Service. Our Archaeology Service is keen to note that this condition is used widely beyond Aberdeenshire. Our Archaeology Service also covers Aberdeen City, Moray Council and Angus, in addition to Aberdeenshire. So it is a very commonly used condition in this part of the world on a whole range of proposals, but perhaps honing into the particular criticism from Mr. Hutchison on this. The advice that we've received from our Archaeology Service is that the stopped works is until the submission of the PERD and the agreement of the PERD being the post-excavation research design, which can include timescales for the analysis, publication and dissemination and results of, and the archive deposition. So it's really about making sure that there's a plan for any information that comes to light during excavation, which I'm glad that Mr. Hutchison has said that he would expect on a development like this, should there be unforeseen archaeological discoveries on site. So the additional wording within this condition is just to make sure that I suppose not only is as currently unknown, potentially unknown archaeological remains are not only identified and dug up, but also properly recorded, or at least a programme is put in place for these to be properly recorded and registered in the appropriate manner. So it's perhaps a bit of misunderstanding, or perhaps there's a bit of clarity needed in respect of that. But the council's expectation is that the delay would be until the PERD is agreed, and that details around further timescales can be contained within the PERD for those other later stages of that condition.
Okay, thank you. On the version of the schedule that I have, there's some wording in blue under the council suggested document, and the opposite column it says council to provide additional clarification. Is the blue wording the additional clarification, or is there more to come? Is there something additional that you wanted to add to that condition?
I'll show which bit that is because I don't have it in colour.
It's on page 39 of the schedule, and at the bottom half of the column, some blue text.
Apologies, sir. I've got it printed out and it's in grayscale here, so I'll need to get the online copy of it.
So does the blue text begin, should the archaeological works reveal?
Yes, it does.
I would say that the clarification I've given in terms of the discussions with our Archaeology Service covers that clarification, and it would be that the timescales for anything beyond the PERD can be covered within the document and agreed as part of that document. So it can, I think that would be all we would say in respect to that.
Okay. Anything you'd like to add, Mr. Hutchinson, on what you've heard?
I think only so it goes back to this whole thing about delivery of green energy, clean electricity is an important policy objective. But equally, the delivery's got to be effective. And one of the issues is that the construction of a wind farm is a complex infrastructure project involving numerous parties and also grid connection, electrical interconnection. The idea that everyone sits doing absolutely nothing until effectively some archaeologists who approved a report about what was found is simply not acceptable, because the construction and commissioning of a wind farm needs to all happen according to the programme. And simply put, the idea that we can just stop whilst we've constructed things is just not going to happen. So it really is a very, very difficult condition to apply. And my suggestion is there's no reason why these matters can't be properly dealt with in the written scheme of investigation and any reporting arising from it, provided that there's appropriate means within the written scheme of mitigations to be approved. These details can all be approved in that scheme. And this is a classic example of one group of individuals producing what might call a special interest condition, which is utterly disproportionate to the issue at hand. And as I say, I think it's that whole thing of unintended consequences. But this type of condition is exceptionally difficult to manage because it then becomes a risk. And quite frankly, the risk isn't actually even manageable because it relies on a third party, somebody in the archaeological department, approving a future plan. And that's why we generally seek to discharge everything as pre-commencement conditions. We discharge the pre-commencement so that we get a clear run at the construction and commissioning in accordance with what we've agreed to do. Putting in tail pieces like this undermine that process and make it virtually impossible to deliver infrastructure projects. So I just say it's a very simple point, and I think it's just an overstated, over-enthusiastic special interest condition. And I think all that needs to be done is perhaps toned down, and I'm sure that within a written scheme of investigation, appropriate reporting requirements can be put in place and the matter dealt with without this level of formality that seems to be being put forward.
Okay, thank you. Anything you'd like to add, Mr. Finlay or Mr. Hewitt?
Yeah, perhaps I can just add something that we don't accept it's a special interest condition. And we do say that it may be unlikely to arise, but there will be appropriate cases where something not considered at pre-commencement stage is found to exist, and a proper scheme for dealing with it is required that doesn't just permit construction as if what was unexpected had been found didn't exist. And it may be the wording can be altered, but that proper provision needs to be made for dealing with the, if I can use the expression, the unknown unknown that may appear in the ground under the proposed turbines. It's no different, if I can give evidence, taking a leaf out of Mr. Innes's book, from a project I'm involved in rebuilding Perth Town or City Hall at the moment, where unexpected archaeological remains were found and work had to stop for 2 months. It's a significant infrastructure project, but that's what had to happen.
To come back on that, this condition's got
yes,
nothing
please
to
do.
Yeah, it's got nothing to do with that. This is about, should the archaeological works reveal the need for post-excavation analysis, the development hereby approved shall not be occupied or brought into use. It's got nothing to do with stopping development. It's at the end of the day, what they're trying to say is in order for my special interest report to be given the importance that it deserves, you shouldn't be allowed to use the project or occupy it until that report has been submitted and approved. I think I couldn't get a clearer example of a special interest completely overstating its position and trying to exert a degree of control which is wholly unwarranted. At the end of the day, if they want to report about these findings, it should be in the scheme of investigation, and they can seek to enforce that if there were no forthcoming report if necessary. But the idea that there should be a special no occupation condition whilst we await a report to be approved by the Archaeological Service, it's not about protecting archaeology, it's all been done. It's about a report about something that has happened has got to be approved. And in my submission, that's utterly disproportionate to the, and again, if I may say, it's an attempt to introduce a stop notice to allow an archaeological report to be submitted. There's no planning justification in terms of that requirement, and in my submission, it should be, it would be wholly inappropriate to incorporate that level of control for the submission of a report, which is the basis of it.
Okay, thank you. Okay, now we come to a series of draft conditions that are contested, particularly on whether there's actually a need for them. And these cover kind of drainage, visibility splays, and borrow pits. The first one on drainage, I see the applicant's preference is to include this within the CEMP, which is condition 10, draft condition 10. But the council would prefer it to be a standalone condition. Mr. Hewitt, perhaps I could ask you to address that matter first, or Mr. Finlay indeed.
Yes, sir, thank you. If you'll allow me, actually, it's a very similar issue to that with condition 25, the borrow pit details. And in speaking to both of those, really these are quite important aspects of the proposed development that, to be quite frank, ordinarily the council would expect to be fleshed out in quite a detailed fashion at application stage. Certainly if this was an application under the Town and Country Planning Act that the council was dealing with, we would probably have wanted more information on drainage details and the specifics around the borrow pits to be submitted for consideration. So whilst I acknowledge that it may be possible to fold these into the CEMP, our fear would be that they are lost slightly in the mix. Within that, so a standalone condition would encourage a standalone submission of these details. And as referred to earlier, it's almost a usability and administration issue for us, where as a planning officer, I'm unlikely to come to a decision by myself in relation to drainage details or borrow pits. I might be wishing to speak to other consultees. So if this package of information is clearly labelled and submitted as drainage details under condition 23, that's a lot easier for us to process and to share with our colleagues within our flood risk and coastal protection team, and hopefully should enable a quicker turnaround of those aspects. So I would say that there's perhaps a benefit to that. I do have further notes for the borrow pit condition, but perhaps I'll wait until we get on to that. So I'll leave it there in respect of condition 23.
Okay. Mr. Hutchinson.
Yeah, again, we're sort of going back to the points that we made on the SEMP condition itself. In drainage details, even looking at the list which is in the SEMP condition, is integral to that. The control of pollution, all the rest of it, all comes down to drainage details. Would expect an appropriate level of detail to be provided in the SEMP. I don't think including it within the SEMP rather than having it separate in any way reduces the need for an appropriate level of detail. alternatively, I think taking it out takes it away from being integrated with the other processes that are listed in the SEMP condition. And again, gets you into the same situation as we discussed earlier, where you have multiple documents, all having to be referred to, all potentially saying slightly different or conflicting things because they've been approved in a different process. So I think to achieve the outcomes, again, that this is designed to achieve, it is far more practical to have it simply included within the SEMP. And I don't accept, that having it separate, or sorry, yeah, having it separate prevents it from being lost in the mix, I think was the word that was used, or simply to sort of make it more convenient for the council and its administrative processes. I don't think that's really the intention of the condition. The condition is to stop and manage the construction process and prevent harm from arising.
Okay, thank you. Okay, we'll just perhaps jump ahead one to draft condition 25 on borrow pits. Same discussion. I think you alluded to that, Mr. Hewitt, but you wanted to say something specific about the borrow pits condition.
Yes, sir. I won't rehash what I've already said in terms of being a separate condition, other than, it's a really quite significant aspect of the development, and they are in effect for small quarries that would be created. So I think it's very important that we get an appropriate level of detail for those. Just in terms of looking at other decisions that have been made, because I note that in the applicant's comments for this particular condition, there is concern about the trigger for the provision of details, and that it should be at the commencement of the borrow pit activities rather than commencement of development. If this is included within the CEMP as proposed, it would be prior to commencement of development as a whole, as opposed to commencement of borrow pit activity. And just in terms of adopting the trigger that the council wishes within this condition, that it's pre-commencement as a whole, that is in line with the decision on Paul's Hill, where condition 13 part I uses no development shall commence, and it's similar to the Crystal Rig CEMP condition. It's incorporated within that, but again, no development shall commence until this information is provided. And then just in terms of content, on reviewing other decisions since we put forward wording for this condition, if you were so minded to attach a separate condition, we would encourage you to look at the North Lothian condition, which is condition 10 within that, which is perhaps slightly more specific and does go further than the list of points A to E, which I've included within that condition, but that may provide a useful basis if you're looking at what to include within a standalone condition.
Mr. Hutchison, your thoughts?
Similar to sort of previous comments, sir. The winning of aggregate on site for use on site as part of the roads and everything else is part and parcel of the construction process of a wind farm like this, and doesn't sort of necessarily benefit from being separated out. Again, just coming from practical experience. So yeah, I come back to the earlier point. I think that the more integration we can have, and the more holistic sort of nature that we can bring to that process, then the easier it is to implement, and the more successful it's likely to be.
Okay, thank you. Just going back the way to condition 24. Draft condition 24 deals with vision displays. Now, this was brought to my attention when I visited the site, and I see that the council, in its writing of the draft condition, would like to impose further vision displays, but also, the applicant points out that it's an existing access that serves the needs of Mid Hill and also Forestry Land Scotland, and so there's also a bit of tension there. So perhaps I could start with you, Mr. Hewitt, why you feel it's appropriate to impose further visibility, the need for further visibility displays at the entrance to the site.
Yes, sir. Thank you. In looking at the need for visibility displays, we've based this on the assessment of our routes engineers, and actually, as a result of discussions on the conditions, we did have one of the senior roads engineers go back out on site to consider whether those detailed in the original response were necessary, which is how we've ended up at the two different lengths referred to within the condition. As to the appropriateness of attaching a condition to an existing access, I would say that this reflects the changing use of the site, and whilst I accept that the impacts are likely to be primarily during the construction phase of development, I think we need to remember that the turbines that are going to be brought onto this site are significantly larger. So I think given the seriousness of road safety as an issue, a conservative view from the council in terms of ensuring appropriate access is upgraded to ensure appropriate access, particularly given as this location is frequented by various members of the public for recreational use. I think it's entirely appropriate, and I think it's entirely sensible for us to ensure that the access is as safe as possible. But I would reiterate the point that while the access may have been suitable for previous iterations of Mid Hill, the turbines that we are looking at now are of an entirely different scale. As to whether or not we would accept a lesser standard, I'm not a roads engineer, I wouldn't be able to comment to that. So we would be deferring to the advice we've got from our colleagues in road development at this stage. But I think that's all I have to say.
Thank you. Mr. Hutchinson, we are dealing with potentially larger turbines and blades. So there may be some merit in what the council's saying there about introducing further vision displays at the entrance. But I'll be interested to hear what you have to say on the suggested wording.
Thank you, sir. I think fundamentally we would question whether this proposed condition meets the test of relevance as set out in Circular 4 of 1998. There is an example provided in that test within the circular, which seems to draw a number of parallels with this situation. I'll quote it. It says, for example, if planning permission has been granted for the alteration of a factory building, it would be wrong to impose conditions requiring additional parking facilities to be provided for an existing factory simply to meet a need that already exists. Well, I think that this comes down to what's required to accommodate the proposed development, as opposed to what already exists to serve the existing junction, the forest of Fetteresso, and the various users of that forest. In my mind, the junction is already wide enough to accommodate the blades that are being delivered to site, there's no, in terms of what the council have suggested, there's no, it's not envisaged at this stage that we will be applying for any sort of new road construction consent or adoption from the council. We're simply using a junction which already exists and which has already been adapted for the purpose. This idea that we need a different visibility splay because we're delivering larger blades to the site seems puzzling for me, because the blades are being delivered into the junction, not coming out of the junction. So the visibility splay is there to control what comes, the visibility from vehicles leaving the junction, not the ones that are coming into the junction. So I don't really see that it matters about the blade length in that respect, or that there's any connection between the two points. I think, you know, if we get into the detail, we would question some of the geometry that's being asked for as well. And I think if you look at the Blairgower consent which has been suggested, then the setback distance from the junction is 2.4 metres as opposed to 4.5. But I think without getting into that level of detail, we'd sort of fundamentally question that the imposition of this condition has any relevance to the application being proposed. We've already discussed and already accepted a traffic management plan condition, which is geared primarily to deal with the construction traffic, and I would expect that would deal with any particular issues that might arise during that phase. As a matter of goodwill, the applicant is willing to agree as part of the TMP to trim the verges within the council road verge to ensure adequate visibility is maintained, but it shouldn't be something which is then imposed on a user of this junction through the entire life of the development. The day-to-day use after the construction phase has ceased will be a very small number of operational staff in standard vehicles, normal sort of domestic type vehicles, rather than abnormal loads or anything like that, coming in and out of that junction. And that level of use is less than the existing level of use that would arrive from the use of the site by the Forestry Commission, the landowners, or the recreational users of the tracks and that junction. So I don't see that the condition which is being suggested in any way relates to the development which is being permitted, and so the condition itself is unnecessary.
Thank you. Is there anything you want to come back on there, Mr. Hewitt?
Yes, thank you, sir. I'd just like to pick up the reference to the circular and the relevance of the condition to this proposed development. I think it's slightly disingenuous to compare the extension of a factory to the extension of a wind farm, particularly when the wind farm in question is going to contain turbines ranging in height from 149.9 metres to 200 metres. Because there will be undoubtedly an impact of infrastructure being delivered to this site, and yes, it might be limited to the construction period, but as I stated, the council is admittedly being conservative in this matter, but I think road safety is worth taking a conservative approach to. It's ultimately not really a risk worth taking. But I won't stray into the specifics of the geometry of this particular visibility display. As I said, it's been recommended by the council's engineers, and as a service, as a planning service, we see no reason to ignore this advice.
Something you'd like to add, Mr. Innes?
I just want to come back on this. There's three elements of transport movement. One, there's general construction traffic, which again will be dealt with in the TMP, and it incorporates a whole lot of discussions about these general matters. And in my submission, in general terms, the management of traffic volumes through that junction will be a matter for the TMP to consider, and it may well be that arising from that, management measures are introduced. Now, one of the management measures that may well be introduced is temporary speed limits in relation to the vicinity of that junction, arising from the number of movements and the nature of movements that might be involved. And you'll be fairly familiar from passing through elements of where there may be speed restrictions. That in turn would have implications for the any visibility space, because that is one of the justifications for some of, it would appear, for some of the dimensions. So first of all, in my submission, the proper course for where that should be considered is in the course of the formulation of the TMP, where these matters will be fully canvassed with the numbers and anticipated transportation movements. The second matter, which appears to be primarily in the council's mind, and they seem quite excited about the size of the turbine blades, is so weird about their efficiency. But in terms of those particular movements, they're abnormal movements, and there's a separate set of provisions within the TMP that deals with those particular movements. And to suggest that they won't be properly managed and supervised is wrong, because it's also going to potentially have to travel on trunk roads, and the Trunk Roads Authority have also requested aspects of this condition to ensure that all the measures are properly dealt with by a QA traffic management consultant. So in order for those particular movements to be conducted safely, we already have movement plans for the trunk roads of Transport Scotland involved in ensuring who's actually doing it. But it is actually, again, a very specialist manoeuvre, at which point it will actually usually be accompanied by various vehicles. And again, traffic management is a standard part of the process of abnormal routes. And in terms of what we do when we're dealing with these abnormal movements, is we do all sorts of things like remove road signs, street furniture, etc. It is all part of a temporary process, which is then reinstated. So again, in my submission, to start reorganising alignment of roads for that temporary position, unless it is required for those particular movements, is not necessary. So that covers the construction. And then we come to the operation, where, as again, the operational levels are so small in relation to traffic movements that if one was suggesting that you were going to add a house or one house to this junction, would you be saying that I need all these junction improvements given the existing use that already using it with no safety record? You certainly would not. And in my submission, the operational use is so slight, it would not justify seeking to reorder this particular junction for that very limited nature and extent of transport. The primary use of the land in and around here will continue to be forestry and elements of recreational use. And certainly we are not the primary user of that access. And it would be completely inappropriate for this development to have to essentially provide a different form of access from that which has been provided. It's entirely adequate for the purposes and the extent of usage which is promoted in terms of this development.
Okay, thank you. Any further comment from the council?
No, thank you. Thank you, sir.
Okay, thank you. Okay, that takes us to item 4 on the agenda. I should put the need down for an obligation, another legal agreement, but I see in the statement of agreement between the parties that both parties agree that there's certainly no need for any obligation or the legal agreement in the context of this application. So, so before we close this hearing session, I wonder if there's any other matters that the parties wish to raise. So I'll go to the council first, Mr. Finlay.
Not on conditions. I think the only thing that we think may be outstanding is a time schedule for closing submissions.
Yes, yes, indeed. I'm going to come on to that in a moment. Mr. Innes.
No, sir, apart from I think you've left us some homework to make sure that we follow up with the CAA correspondence. We provided the plan, I think, of the 5 lower turbines. I don't know whether that suffices or whether Mr. Finlay wants a formal input to the process, that's the basis of which the EIA are prepared. If he does, I'm more than happy to arrange for that to be confirmed as well, if it needs to be formally done. But as I say, the ES talks about the 5. I have absolutely no information that suggests, and I have confirmation it does. But insofar as that, I think that was a matter that he wanted. So if that's required, I'll get it, but I'll need to get a formal position written to me before we can submit that. But if that's what Mr. Finlay would like, I'm more than happy to seek to arrange that.
Okay.
Well,
Okay. Mr. Finlay.
Never want to refuse an offer from Mr. Innes. I think it would be useful to have it confirmed that the turbines as shown in the visualizations have it confirmed that the turbines shown in the visualizations do differentiate between those at 110 and 125, but the plan that's been submitted so far is quite sufficient to identify which turbines are at 110.
Okay, thank you. Mr. Innes, I would just add that I have that plan myself, and I also have the Aviatica report and the CAA response. So I've now received those. Thank you very much.
So I've only got one piece of homework outstanding, which is Mr. Finlay's letter.
Indeed.
Paper.
Okay. Okay. Moving on to closing submissions. I presume parties are content to make their submissions in writing, and those should address all topics upon which a party wishes to make representations, including any submissions on the evidence heard at the inquiry or hearing sessions. For the benefit of those not familiar with this exercise, submissions should not contain any new evidence. So I'd be interested to hear on your response to the suggested timings of submissions. Mr. Strong, the convention is that objectors to the application, if they wish to make any closing submissions, they do so first. So you're able, if you wish, to submit something further. Obviously, you submitted something prior to the inquiry, but now you've had the opportunity to hear the evidence, and you may make a submission on what you have heard. I was going to suggest that if you wish to do that, that perhaps we get those from you by the 10th of November, and it'll be the same for Mr. Burgoyne and the Community Council as well. I see they're not on the call, so I'll make sure that they're aware that they have that opportunity.
So is that a written submission by the 10th of November? That's not a submission that I will give now.
No, it's a written submission that you submit on the 10th of November.
Right. Okay.
Although I've yet to confirm these dates, so but my working assumption I would give you a week, to do that. And then if you are going to make submissions, you should copy it to the other parties. So a copy to the council, a copy to Mr. Innes, and also the Community Council. Okay. I was then going to suggest that perhaps the council would submit their closing submissions a couple of days after that. And then finally, the applicant would have some time to respond with its closing submissions. And I was going to suggest the 19th. So the 10th for the objectors, the 12th for the council, and the 19th for the applicant. And I'd be interested to hear from Mr. Finlay and Mr. Innes whether those timescales work for you. So Mr. Finlay.
So just looking at our timescales, if I could possibly ask you to stretch that to the 15th for myself, Mr. Brown, so it gives us just a weekend, because I know we both have fairly busy diaries.
Okay, happy with that, and I could then extend that to the 22nd for you, Mr. Innes. Or would you prefer? Would you need a little bit more time?
So it's not really much of an extension for me. I'm in a public inquiry the following week from Monday till the Friday anyway. So I'm happy to just try and get this closed. So I'd be keen I'll have it submitted by the Friday the 19th.
The 19th.
Yeah.
Okay. Mr. Strawn, once we've closed and you've got some further questions, again, please don't hesitate to drop an email to my colleague Morag, and we're happy to help you with the kind of procedural aspects of it.
Okay, thank you very much.
So before I close, I wanted to thank Mr. Innes and the applicant and the council and the Community Council and local residents for agreeing to participate in the new administrative arrangements for dealing with the Section 36 consent applications, particularly with the preparation of the position statements at the outset of this process, and also the assembly of the core documents. Never an easy task, but certainly it's proved to be very useful having all the documents assembled in the way that they have been. So thank you for that. And as you know, the intention of these changes was to make the process more efficient and to allow me and my colleagues to deliver reports to ministers more quickly. So with that in mind, I aim to have my report ready for submission to ministers, perhaps towards the end of January. So that's my working time scale. So all that remains really, if there's anything else that anybody wishes to raise before I close the inquiry, now's your opportunity to do so. Mr. Finlay.
Well, mainly just to thank you, sir, and to say that whilst there were some communication hitches during it, I think pretty well every person involved, I'm grateful to you for bearing with us and seeing the inquiry through. Okay, thank you very much.
Okay. To Finley's comments, and also your backup team that supported the inquiry process. I'm certainly Jim Hudson and Kenna Bissett from our team have been instrumental in pulling together all those documents and helping us to try and bring this to as order as possible. And I think also recognising the importance of the Community Council and the councils spending time up front. There's been a lot of correspondence that you haven't seen in us trying to progress matters, and that's been extremely constructive, and throughout the process it's been a very constructive dialogue between the parties in trying to progress matters, and that certainly has greatly helped and narrowed issues. And I just I wanted to formally acknowledge that, because it goes often behind the scenes, but there's been a lot of work and it's been done very professionally, and as I say, we may have differences over various matters, but they've been formulated in a structured fashion and are much narrower than they would otherwise have been. So I just want to record that aspect. Thank you.
Okay, thank you very much. Okay, with that, I shall close this inquiry session. Thank you very much. Thank you. And thank you, Mr. Strong. Thank you.